All right, so it looks like the live stream is up and running. We are here for the first round of this year's Summit Cup tournament. If I could start with entries of appearance with the plaintiff first.
Yes, Your Honor. My name is Hannah Parman, representing the plaintiff, and I'm joined by my co-counsel, Alexandra Bartos O'Neill. And
Evening. Hold on one second. I'm so sorry. Sorry, I'm having some feedback. Every time I speak or you speak, it's replaying it to me. So hold on one second. Maybe I can. All right, let me test this, see if it gives me any feedback. I apologize for the delay.
no problem. Is this better?
Yes, it's much better. I think I just had to cancel out of the live stream. So I apologize. If we could start again with plaintiff's entry of appearance, that would be great.
Yes, Your Honor. My name is Hannah Parman, representing the plaintiff, Cam Donaldson. And tonight I'm joined by my co-counsel, Alexandra Bartos O'Neill.
Good evening.
Good evening. Thank you. If we could have entries of appearance for the defense.
Good evening, Your Honor. My name is Jack Ayers, representing Karen Beja. With me as my co-counsel.
Good evening, Your Honor. My name is Enrico Trevisani. Pleasure to be here.
Thank you for the entries of appearance from defense. Before we get started, I'd like to do a conflicts check with both of the scoring jurors to determine whether or not they see any conflicts with the names of the witnesses or any of the attorneys that are representing the parties.
No conflict.
I don't, Your Honor. Thank you.
And I also do not see any conflicts that would prevent me from being the ruling judge. All right, now that we've done the conflicts check, it looks like we are already on live stream. Is the plaintiff ready to proceed?
Before we begin, Your Honor, we have a few housekeeping matters to address.
And we'll get right to those. I'm going to swear you in. I just want to make sure that both sides are prepared to proceed. Is defense ready to proceed?
Your Honor, point of order. We believe that the defendant in today's case is still in the waiting room for this call. We just want to make sure she's here before you swear in the witnesses.
Yes, I appreciate that. Let's see. All right, does it look like we have all of the witnesses now present in the waiting room?
Yes, sorry for
Both of our witnesses.
And for the plaintiff, are both of your witnesses present?
Yes, Your Honor.
All right, so now that we have all parties present, what I'm going to do before we begin is swear all of the parties in. If everyone could please raise their right hand and please indicate I do if you agree with this statement. Please indicate by saying "I do" if you swear to abide by the rules of this proceeding and conduct yourselves in a manner that is honorable to this forum. We will start with the plaintiffs. If you agree with that, please say "I do."
I do.
And the plaintiff's witnesses.
I do.
I do.
Okay. And does the defense agree to proceed with the oath? I'll start with both defense attorneys.
I do, Your Honor.
I do.
And what about both of the witnesses for defense?
I do. I do.
Thank you. All right. We will now start calling the case number 8082263, Cam Donaldson versus Karen Besa. Are there any housekeeping matters in which the plaintiffs would like to address?
Yes, Your Honor. First, we were wondering if in this jurisdiction, experts must be tendered, or should we just lay foundation and proceed with treating them as expert witnesses?
I would like you to tender the expert after you've laid proper foundation. That would be great.
Yes, Your Honor. And we met and conferred with opposing counsel earlier, and we agreed that we would like to request a 5-minute recess between the two cases in chief and prior to closing arguments as well.
I have no objection to that.
There are a couple exhibits I intend to show during opening. One, which is Mr. Donaldson's glasses and keys, a photo that is found in the packet. We stipulated to the admissibility of that. However, there's another exhibit, which is Bates number ending in 0016, which is an application for a restraining order. I would like to display that briefly during opening arguments as well. However, I believe that will be a subject of motion in limine. So assuming that that comes in, I just wanted to inform the court that I intended to show that during opening arguments.
Okay. If there are items that have been stipulated by both parties and there's no objection to show those documents in opening statements, I will allow parties to do that. If there is a contested document, depending on what the ruling is in motions in limine, I will not allow the parties to show those documents in opening statement, especially if the objection during motions in limine depends on foundational issues or issues revolving around prejudice. So you are allowed to show the two stipulated in opening, but I would ask you to refrain from showing any additional documents that have not been admitted with defense's objection.
Yes, Your Honor. And just to clarify, may I mention the document and just not show it, or would you like me to refrain from mentioning it and opening it all?
Let's hear the motion in limine to determine why defense is attempting to exclude that document, and I can make a better ruling at that time.
Yes, Your Honor. Speaking of stipulations, there were two other items that we did stipulate to earlier. The first is that in keeping with the pleadings in this case, both parties consider Lou Donaldson at this point dead, as he has been legally declared. And the second is the admissibility of a deposition transcript from a man named Carl Bannister, who is an unavailable witness, and both parties stipulate to the admissibility of that document.
Thank you for those stipulations. I will make note for the court.
We wanted to ask that no witnesses be considered sequestered in this case. There are the two parties, and we believe that the other witnesses are being treated as expert advisory witnesses. And so in keeping with the rules of evidence, they would not be sequestered.
That is granted.
Just two more. The first is whether Your Honor has any specific preferences for how we handle exhibits. When we spoke, we both understand that given the format, well, we would in an in-person trial show documents to one another prior to introducing them to a witness. That won't be possible, and we were both all right with that, but wanted to see if you had a specific preference.
Have the parties come to an agreement as to what would work best for showing exhibits, whether or not that's listing a bait number or sharing your screen. I will defer to the parties if you guys have come up with a way that is best for you guys to conduct your trial.
I believe for speaking for the plaintiff, we intend to not display the document until it has been deemed admitted. I don't know what the defense plans on that are.
We also plan not to put the document on screen until it's been admitted. In terms of communicating with both the court and with the witnesses on the stand, we'll be describing any documents that we intend to enter into evidence using their names, such as Donaldson Deposition Exhibit 1, that sort of thing.
I have no issue as long as you guys are identifying what document you are discussing, so there's no confusion if there needs to be an objection made in regards to the admissibility. So I'm fine with not displaying it until it's been admitted, as long as there's a description so both parties can properly state objections if necessary.
Yes, Your Honor, and I believe plaintiff will be using Bates numbers. We may, in addition, describe the document in the same manner as defense counsel.
Okay, great.
And then finally, a logistical point, speaking on behalf of myself and my co-counsel, both of us are working in sort of studio work from home situations. And as a result, we were wondering what Your Honor's opinion was on blacking out screens when we are not the ones speaking or preparing to object, just to avoid distractions for the jury. Additionally, on a personal note, I do have a dog who is in the studio situation with me, and so wanted to let everyone know that if barking happens, I will mute myself and deal with it as quickly as possible.
I would like the attorneys to remain on screen. I think that causes less confusion, and then everyone else, witnesses and jurors, can mute themselves. And then I will just ask that all parties please keep their microphones muted unless they're speaking, which you guys have done a great job of now, just to prevent any type of interrupting when another party is speaking.
Yes, Your Honor. I believe that's it for housekeeping from the plaintiff's side.
Thank you. Any housekeeping matters from defense?
Yes, Your Honor. First, just a clarification point. Would you prefer that we keep our cameras on even when our co-counsel, for example, is direct examining or cross-examining a witness that we personally don't interact with?
That's a good question. That's fine. If you want to mute or black out your screen so it's just your name, and then that way it's just focused on the participant that's presenting, that would be great.
Great. Second, Your Honor, we understand that you've received an electronic exhibit notebook. We just wanted to make sure that was the case.
That is correct.
And finally, because we're unable to approach the bench, we just wanted to ask if all objection arguments could be heard constructively outside the presence of the jury.
That would be great. I would just ask if you want to make a speaking objection, just to ask to constructively approach the bench. And then that way, all of the other parties are not privy to the information constructively.
Of course. We have no further housekeeping issues. We're ready to move on to substantive motions.
Thank you. I will start with substantive motions from the plaintiff.
Yes, Your Honor. Before I begin with our motions, I have two today. Would you like me to pause in between each of those motions to allow defense counsel to respond in order for just clarity?
That would be great. We'll take one at a time. Thank you.
Yes, Your Honor. Our first motion is we would like to move in limine to enter a redacted version of the application for the restraining order, as it is admissible under Evidence Rule 8033. As an offer of proof, this document contains statements written by Mr. Donaldson. These statements contain statements that fall under the exception of 8033, including his state of mind. He mentions that he's seeking a divorce from Karen Baja, that he doesn't feel safe around her in lieu of her threatening to kill him. And those indicate his state of mind and thus would fall under that exception. And furthermore, the statement by Karen Baja that's contained within that statement would be a statement by a party opponent and not hearsay. For the redacted portion, we intend on offering this document as it is, except for the denied stamp at the top of it. That's the only part we would like redacted under Evidence Rule 403. And our reasoning is that we do not know the reason for why the judge denied this claim, denied this application. It could have been for a filing or a clerical reason, and we aren't able to question that judge as to his reasoning. We believe that seeing that denied stamp would substantially prejudice the jury. Therefore, we would move to admit this document, a redacted version of it.
Thank you. Any response from defense?
Yes, Your Honor. First, this document, even unredacted, would be inadmissible under Rule 403 as well as hearsay. But this document, as redacted, is even more prejudicial than it already is. So under 403, Your Honor, this document, even without that redaction, it's substantially more prejudicial than it is probative. The probative value of this document is very little. We as the defense, we'd be happy to stipulate that this request was made. And if that was all that opposing counsel was using it for, then that probative value would be met with that stipulation. But they want this for the statements on the actual document itself. And these statements, we believe, would highly prejudice the members of the jury against our client. Now, as opposing counsel mentioned, this request for a restraining order was denied. So for the members of the jury to see the documents on this request, which were already deemed by a judge to be either insufficient or not credible, they would give those words far too much weight and it would prejudice them against our client. Now, opposing counsel is trying to take away the word denied from this document. We believe that makes it even more prejudicial because the members of the jury might actually think that this document was accepted, that this restraining order was accepted by the court, and that certainly wasn't the case. There was never any restraining order against Karen Beja, and so this admission would be improper for that reason. We also believe the specific statements would not fall under the exceptions listed by opposing counsel under 8033 and would be considered hearsay statements as well.
For the plaintiff, can you please give me an offer of proof as to what the relevance of this particular document is for purposes of your case?
Yes, Your Honor. The relevance of this document is we want to provide evidence that Ms. Beja had some motivation for causing Mr. Donaldson's death. That is one of the elements that we had to prove in trial. We will have to prove in trial today. This document will show the potential motivation that she was facing from a divorce from Mr. Donaldson and would thus be at risk of losing her lifestyle that she currently had. And as a result, this would be the relevant value of that and would outweigh any potential prejudicial note on the jury.
Okay. Any final word from the defense based on the relevancy of this document?
Well, Your Honor, we don't argue that this document is irrelevant under Rule 401. We just believe that the prejudicial value is incredibly high. As we stated, if opposing counsel is just using this to show that this request was made, that they're using that to derive motive, we're happy to stipulate to the fact that this request was made. But these statements on the actual document themselves, if seen by the members of the jury, could be given undue weight. Again, this document was denied. A judge did not find that there was sufficient evidence to actually grant this restraining order. So for this to be admitted, particularly in this redacted fashion, it would cause undue prejudice. It would mislead the jury potentially into believing that this restraining order actually went through.
I'm going to reserve ruling on this particular issue, specifically since defense has indicated that they have no objection to maybe a series of questions that this was requested, but without getting into the underlying details. I'm concerned with not knowing what the hearsay statements specifically are and being able to see which statements the plaintiff is attempting to admit. I also have concerns under 404 that this potentially will be used as propensity or character evidence based on the offer of proof in regards to what it would be used for. So at this time, I'm going to deny plaintiff's request for admission. If at some point it does become relevant in the trial, I would just ask that the plaintiff approach the bench outside the presence of the jury to indicate that you are going to attempt to either lay foundation or admit this particular document so we can determine whether or not it's appropriate at this time. I would also, based on the housekeeping motions, request that the plaintiff refrain from displaying this document in opening statements. Again, based on defense's indication that they have no objection to the mention that it was requested, I would have no objection to you mentioning that in opening statements if appropriate.
Your Honor, may I proceed to my second motion?
You may. Thank you.
Your Honor, we also move to admit Exotic Bob's testimony, particularly regarding statements that were said by Karen Beja to him as admissible under 801 D2E and Evidence Rule 807. As an offer of proof, we believe that the statements from Karen Beja to Exotic Bob are statements by a co-conspirator and in furtherance of a conspiracy, and thus would be admissible under 801 D2E. As an offer of proof, we understand from the context of Exotic Bob's testimony that he and Karen Beja were engaged in a conspiracy to illegally import big cats. And the statement that was said by Karen Beja to him was a threat if he should he were to tell on her to the police or potentially rat her out, and thus this statement would be in furtherance of a conspiracy. Furthermore, we expect that there will be further corroborating evidence from Karen Beja indicating a relationship between her and Exotic Bob, specifically that after he went to prison, she obtained all of his big cats after the proceeding. And furthermore, this also would qualify under Evidence Rule 807, specifically because it does have a level of trustworthiness given the situation that these statements weren't given under any coercion or pressure. And as far as we're aware of, Exotic Bob isn't receiving any compensation of any sort for making these statements. And furthermore, given that Mr. Donaldson disappeared over 8 years ago, this testimony is especially probative and on point, given we can't make any other reasonable efforts to determine what happened to Mr. Donaldson, given the time period that has passed. Therefore, we ask that this evidence be admitted.
Response from defense?
Yes, Your Honor. First, to that 801 D2E argument, Your Honor, first, the statements by this person named Exotic Bob, well, this is the first that we're hearing that opposing counsel is contending there was a conspiracy between Ms. Beja and this man. There was never any statement of conspiracy in the indictment in today's case. We have a good faith basis to believe that none of the elements in today's trial that are at issue relate to a conspiracy between these two individuals. So it would be improper to use this mode of exception to bring in this statement. Now, we did stipulate that the statements by Exotic Bob are that Exotic Bob is unavailable pursuant to Rule 804, but they haven't met any other exceptions within 804 to bring in Exotic Bob's testimony. And Your Honor, this testimony itself, it comes from the inside of a federal prison posted on a webcast online. There's very little corroboration to any statements that are made in the video. And opposing counsel is attempting to use baseless claims that are made within this online video for the truth of the matter asserted. They're trying to bring in those out-of-court statements and assert their truth. And furthermore, Your Honor, to the extent that there has been any cooperation between these two witnesses relating to selling cats or buying big cats, we believe that this is a collateral issue to today's trial. And so if opposing counsel is trying to show that there's other illegal activity that they're accusing our client of, we believe this would be inadmissible as character evidence under 404.
One clarifying question about the video itself. There's been a stipulation that Exotic Bob is an unavailable witness. Is this I'm assuming this is a conversation that he is having with the defendant, Karen. Is that correct?
In terms of the video or the statements that we wish to enter?
The statements that you wish to enter.
Yes, it is a conversation with Karen Beja.
Okay. And you had mentioned in your initial request to admit these statements that there was some type of threats or the sale of big cats. Is that illegal conduct that they are engaging in or having a conversation about?
Yes, Your Honor. I believe the video, the preceding paragraph to the statements that we would like to admit, Exotic Bob describes a relationship with Karen Baj in which they were working together to import big cats. And the subsequent conversation that he had with her was a threat to him that if he were to, if I may make an offer of proof,
Yeah, that would be great.
if he were to cross her in any way, she would do to him as she did her husband and feed him to the cats.
Okay. And is this a statement that Exotic Bob is making, saying, for example, Karen said X?
Yes, it is.
Because he has been stipulated as unavailable, I'm going to find that any statements that he makes that she said fall under the exception of a party opponent. In regards to any additional conversation, I would like you to lay some additional foundation in regards to whether or not a conspiracy exists and it falls under that exception, or more specifically, if there's any type of illegal conduct that's going on, whether or not there needs to be any additional foundation for admissions against interest. And so whether or not any of those statements would fall under that exception, I would need additional foundation to be laid.
And Your Honor, may I clarify on your ruling for that specifically? Are you saying that you're admitting the statements by Karen Baja at this point in time? Because that is all the plaintiff intends to offer.
I will allow you to admit them throughout trial as long as there's proper foundation laid. I don't know, is this a stipulated exhibit or do you intend to bring it in through a specific witness?
We intend, this is in a separate video, and also we have a transcript that we intend to read onto the record essentially.
I am finding that they are admissible at this time.
Okay. Yes, Your Honor. Thank you.
Any further motions in limine from the plaintiff?
No, Your Honor.
Motions in limine from defense?
Yes, Your Honor. The defense has one motion. We move to exclude Ms. Beja's misdemeanor conviction for assault as improper character evidence under Rule 404 of the Federal Rules of Evidence. This conviction, it doesn't fall under the 608 or 609 exceptions. It's not a crime of dishonesty. It's not a felony. And furthermore, Ms. Beja was a juvenile at the time of this event. So we move to exclude any reference to this conviction throughout today's trial.
Response from the plaintiff?
Your Honor, we're happy to concede that on the condition that opposing counsel doesn't offer testimony of Karen Beja's general peacefulness trait, in which case we might refute that particular thing with that piece of evidence.
What rule of evidence are you relying on to admit it on those grounds? Oh, and you're muted.
My apologies, Your Honor.
That's okay.
Your Honor, I believe we are relying on simply evidence rule 404 and also 405, simply to just that if testimony of Ms. Beja's peacefulness were to come up, that we'd have an opportunity to refute that as evidence of her peacefulness trait would also be improper character evidence. We would, of course, object at that point. But just in case that should come in, we would like to have the opportunity to refute that.
So I'm going to find that the misdemeanor conviction is not admissible pursuant to 404 and 608, as well as 403. I do not think that it bears any relevance, nor would it be admissible in a trial based on the fact that it is a misdemeanor conviction and not for truthfulness. In regards to whether or not the door is opened regarding the peacefulness of the defendant, I have concerns about you admitting or discussing a misdemeanor conviction on those grounds if the defendant's peacefulness is brought up, I think that you can certainly under 612 have an additional witness talk about their general sense of whether or not that individual has a peaceful or non-peaceful demeanor or behavior. But I do not believe specific instances of conduct, which would be the misdemeanor conviction, would be admissible. So I'm going to grant defense's motion, and I will not allow the admission of this particular offense or the underlying facts to come into evidence.
Yes, Your Honor.
Your Honor, with that, the defense is ready to proceed to opening statements.
And is the plaintiff ready to proceed to opening statements?
Yes, Your Honor.
Let's begin with the plaintiff.
Yes, Your Honor. Greed is an incredibly powerful motivator. It's destroyed families, cost people their lives. It's even started wars. This case was born of greed. Married to an older man for many years, a man who lifted her up into a life of privilege, Karen Beja was living the good life. She wanted for nothing and was able to devote all of her time to her true passion, the care and conservation of big cats. So as you'll hear today, in the spring of 2012, her marriage was in trouble. That marriage that granted her that freedom and comfort. So faced with the prospect of losing all of that, Ms. Beja killed her husband. This case is cloaked in deception because it wasn't enough that Lou Donaldson died. In order to get what she truly wanted, Ms. Beja had to dispose of his body and forge a will that gave her everything. His $5 million fortune and a $5 million life insurance policy. And so she did. Born of greed, cloaked in deception, she did what she had to do to get it all. Members of the jury, my name is Hannah Parman, and along with my co-counsel, Alexandra Bartos O'Neill, I represent the plaintiff in this case, Cam Donaldson, Mr. Donaldson's daughter. Ms. Donaldson has come before you today to seek justice for herself and for her father. But before I tell you more about Ms. Donaldson and her dad, let me tell you why you're here. You are here today first to determine if Ms. Beja is responsible for Mr. Donaldson's death, and second, to assign a value to that harm that she caused. Not just the economic harm, but the intangible harm as well. Ms. Donaldson's loss of the comfort, love, and support of her father. Now, as the plaintiff in this case, we bear the burden of proving to you by a preponderance of the evidence that Ms. Beja is responsible for Mr. Donaldson's death and the value of the harm that she caused. So in order to meet that burden, we're going to call two witnesses. The first is Ms. Donaldson herself. She'll introduce you to her family and their life. Her dad, a self-made man with many passions, happy to be spending his time working on one of those passions, the care and protection of cats like lions and tigers. His business, Wild Wildlife, was a family affair. Ms. Donaldson worked there as well and had for decades. The co-owner, also very involved, was Mr. Donaldson's wife, Ms. Beja. Ms. Donaldson will also tell you today that her dad didn't just love those cats. He loved his family too, and wanted to take care of them even after he was gone. But you'll learn that in the spring of 2012, Mr. Donaldson and Ms. Beja were having some marital issues, and Mr. Donaldson was planning to file for divorce. When he told Ms. Beja of that, she threatened him. And as a result, he filed for a restraining order in June 2012. Just 6 weeks later, Mr. Donaldson disappeared. On Friday, August 17th, 2012, Ms. Donaldson saw her father for the last time. With no goodbye, no warning, she lost her dad. The next day, August 18th, Mr. Donaldson was reported missing. Now, you'll hear today that when she was questioned by the police, Ms. Beja told them that maybe he'd taken an unplanned trip to Costa Rica. But you'll also learn that he left his glasses and his keys behind, and that there was never any activity on his financial accounts after that Friday, August 17th. And you'll also learn that in the early morning hours of Saturday, the 18th, Ms. Beja and her brother were at the cat sanctuary, a sanctuary which has a meat grinder used to feed the animals, big enough to dispose of a human body. And you'll later learn that Ms. Beja confessed to killing her husband, grinding him up, and feeding him to her cats. And then the deception. On August 19th, Ms. Donaldson will tell you that an alarm went off at the sanctuary. So she rushed down there, and when she got there, she saw Ms. Beja holding a lockbox which contained Ms. Donaldson's father's will, a will that would never be seen again. 5 years later, after she had her husband declared dead, Ms. Beja claimed his life insurance and turned up with a new will, a will that left her everything, his $5 million fortune and a $5 million life insurance policy. Nothing for the sanctuary and nothing for the other members of Mr. Donaldson's family. And that will brings us to our second witness, Taylor Pride, a former police detective and a private investigator in economic crimes. Ms. Pride was hired to look into this case, into Mr. Donaldson's disappearance, and into the circumstances of that will. Ms. Pride will tell you that she looked at the will and the contents and Mr. Donaldson's signature. And she will tell you that based on her 20 years of professional experience, she believes that will is a forgery, born of greed, cloaked in deception. So at the end of this trial, my co-counsel, Ms. Bartos O'Neill, will stand before you and she'll walk you through what you've heard from the witnesses and the evidence that you've seen. And she'll explain why the evidence shows that Ms. Beja is responsible for Mr. Donaldson's death. And so she'll ask you to find for Ms. Donaldson and award her an amount that can only attempt to make up for the loss of her father. Thank you.
Thank you very much. We will now proceed with opening statement from the defense.
May I proceed?
You may.
May it please the court. This wasn't a crime. It was a crash. It's late on a Friday night, and Lou Donaldson is in his favorite place in the world, the cockpit of a twin-engine Cessna airplane. Altitude, 10,000 feet. All he can hear are the whir of the propellers, and all he can see are the stars. And the plane starts to shake. He's hit a spot of turbulence. But he's not worried. You see, Lou Donaldson, he's been a pilot for 40 years. He just needs to check the pressure gauge. So he reaches for his glasses. But they're not there. He forgot them. Members of the jury, after Lou Donaldson took off on August 17th, 2012, he was never seen or heard from again. But the evidence will show that's not because his wife murdered him, disposed of the body, and managed to do so all without leaving a single speck of evidence. you'll learn that the explanation is far less sensational. An older man flying alone late at night without his glasses never came home. This wasn't a crime. It was a crash. And we represent Karen Beja. A few moments ago, the plaintiff tried to describe her to you, but I want you to meet her. Ms. Beja, could you turn on your camera? This is Karen Beja. 19 years ago, she was hitchhiking on the side of the road when a man pulled in to give her a lift. Lou Donaldson. They were married a year later. Their marriage was volatile, but Ms. Beja will tell you that she adored her husband and that in 2012, they were trying to make it work. When her husband disappeared, she was devastated. It's been 8 years. She never remarried. Thank you, Ms. Beja. Of course, we don't have to prove Ms. Beja's innocence. As the defense, we bear no burden of proof. The plaintiff, and the plaintiff alone, bears that burden. They have to prove every single element of their case more likely than not. And they will fail to meet that burden today because of two simple facts. This wasn't a crime. It was a crash. So let's take those one at a time. The first fact you'll discover is that this wasn't a crime. I want to go back a few moments to the plaintiff's opening statement. Let's talk about a few of the things that they weren't able to tell you. They weren't able to tell you, we found the crime scene. They didn't tell you that they knew what the murder weapon was. They didn't talk about DNA or blood or fingerprints. Police. You'll learn that the police investigated Karen Beja. You'll learn that the insurance company sent their own investigator. You'll learn that the plaintiff even hired a private eye. But they found no evidence, none, that Karen Beja killed Lou Donaldson. In fact, you'll learn that they found no evidence that anyone killed Lou Donaldson. That brings us to the second fact that you'll discover. Lou Donaldson died in a plane crash. And you'll learn that Mr. Donaldson loved to fly. In fact, he owned so many planes that even his own family couldn't keep track. Sometimes he took short flights. Sometimes he flew out over the Gulf of Mexico all the way to Central America. But he always flew alone. And he usually didn't tell anyone, not his friends, not his family, not air traffic control, that he was going. On August 17th, 2012, he left the office in a van. And you'll hear that the police, they searched everywhere for that van. At his home, at his office, around town, and they found it. Parked at a private airstrip, next to a runway. And sitting in the front seat were Lou Donaldson's glasses. The evidence will show that this is why there was no blood at Karen Beja's home. The evidence will show that this is why no one saw Karen Beja commit a crime. The evidence will show that this is why no one has ever found Lou Donaldson's body. The police, they searched his home, they searched his office, but they never searched the 2,200 miles between here and Central America. members of the jury, both sides agree on one thing. This case is a tragedy. Lou Donaldson lost his life. The plaintiff lost a father, and Karen Beja lost a husband. But this tragedy involved no treachery. At the end of this case, we will ask you to find in favor of Karen Beja, because this wasn't a crime. It was a crash. Thank you.
Thank you very much. All right, if we could now begin by proceeding with the plaintiff's case in chief.
Yes, Your Honor. May I approach and ask one point of clarification?
Yes.
Your Honor, as an offer of proof, Ms. Donaldson will be speaking about some content, about the existence of the restraining order. And I just wanted to clarify whether you would like me to approach prior to proceeding with that particular line of questioning, if she will not be actually introducing, we will not be introducing the document with her.
Is defense objecting to the discussion of the protection order or just the contents of the protection order?
The specific statements within the request for the temporary restraining order, we're happy to allow any testimony about the existence of that request, but whenever they move into any specific statements, we'll object.
So based on that, I have no objection to you discussing questions with your witness regarding the existence, but if you do intend to get into the underlying statements, I would ask that you approach and make an offer of proof as to what statements you are attempting to admit and under what rule of evidence. I am still very concerned based on the 404 and 403 arguments that were made by defense counsel in motions in limine.
Yes, Your Honor. Plaintiff calls Cam Donaldson. Good evening, Ms. Donaldson. Please state your name, spelling your last for the court reporter.
Cam Donaldson, Donaldson.
Why are you here today, Ms. Donaldson?
Well, Karen Beja killed my father and took property that wasn't hers, so I'm here to try to remedy that as best I can.
So we'll talk some more about that in a moment, but I'd like you to introduce us a little bit to your family. Where did you grow up?
I grew up here in Pioneer County.
Who did you live with when you were a kid?
Well, when I was young and my parents were still together, it was me and my mom and my dad. But once my dad left, it was just me and my mom.
Did your father remarry?
Yes, he remarried Karen.
Did you spend much time with your father and Ms. Beja?
Well, with Karen, really only when I had to. We did work together, but my father and I were close. I was my father's assistant for 20 years, and we spent a lot of time together.
How did their relationship seem to you at the time of your dad's disappearance?
Strained, very strained, constant fighting. It was not great.
We'll talk more about that relationship a little bit later, but let's get to know your dad. Have you always been close?
Yeah, we had. I spent every free moment I could as a kid with him. We always played. I mean, he was busy and a hard worker, definitely, but he always made time for me, and that never stopped.
Tell us a bit about him as a person. What was he like?
He was a good man. He was self-made, a self-starter. He had very little formal education, but he built himself up from nothing. I mean, look at what he created with Wild Wildlife. I really admired him. He was a good guy.
Do you know why he decided to start Wild Wildlife?
Yeah, well, he initially started out selling used cars, and he was great at it. And as soon as he had enough money, he created Wild Wildlife because that was his passion. He loved big cats, and being able to spend time with them and provide them a safe space was his dream.
And were you involved with that business?
Yeah, like I said, I was my dad's assistant. I worked with him for 20 years.
What responsibilities did that involve?
Well, I mean, after 20 years, you really know the business. So, I mean, I pretty much did everything. I scheduled his meetings, I wrote the checks, I kept the books, I made the phone calls. I mean, I did everything.
So you said you were very involved with the business, but were you pretty involved with your dad's life as well? Did you know a lot about it?
Absolutely. I mean, I was his daughter, but I was also his go-to person for schedule, anything professional. I knew a lot.
Do you still work at Wild Wildlife?
No, 3 days after my father disappeared, Karen let me go out of the blue.
So did your father have any other interests besides the cats?
Yeah, he had a few other hobbies, but a big one was he had his pilot's license and he owned a few planes.
Would he generally follow the rules when he flew?
I mean, I guess he didn't always necessarily follow a flight plan as he should have, but he always told me where he was going. Like I said, I always knew when he was leaving, where he was going, his whole schedule. I mean, it was kind of a safety precaution.
We're going to move on to talking about your father's disappearance and the events leading up to and following it. Now, I know parts of this might be difficult for you, so if you need to take a break, just let us know.
Okay.
Let's start with the final year of your father's life. In the months before he disappeared, did anything unusual happen?
Yes. He filed for a restraining order. He got a death threat from Karen and he filed a restraining order. I'd say that was pretty unusual or significant.
Do you know, Your Honor, may I approach? I'm sorry.
You may.
Your Honor, as Ms. Donaldson has mentioned the restraining order and the death threat, I'd like to ask her if she knows what elicited that death threat. As an offer of proof, I believe she'll testify that her father told her he wanted a divorce and that was why. Now, obviously, that may be considered hearsay, but it is in fact a statement of his plan. It would fall under the 8033 hearsay exception. And with your permission, I'd like to proceed with this line of questioning.
Do you intend to introduce any additional statements from the protection order during this line of questioning?
Just the fact that he wanted a divorce, and I believe that there were separate conversations between Ms. Donaldson and her father, independent of just that writing on the restraining order where he expressed that wish to her.
Okay. Any objection from defense based on that single statement from the protection order regarding wanting a divorce as the basis for the protection order?
Your Honor, if there are statements that Lou Donaldson made about the order itself, then we would consider those to be hearsay statements, and we would ask opposing counsel to lay the foundation that there's an exception to Lou's statements. If there are specific statements that this witness can elicit from Ms. Beja, then we would agree that falls under the party opponent exception. As so long as this document itself is not shown to the jury and the statements from the document aren't read, we're fine to move forward.
And do you have, I guess since we're on a sidebar, I'd rather just address, do you intend to lay foundation for a specific hearsay exception in regards to the statements of Mr. Donaldson?
Your Honor, the only statement that I believe this particular line of questioning would elicit is he wanted a divorce, which I believe is not hearsay, as it is in fact a plan and not a statement, an assertion.
Okay. I'm going to allow you to ask these questions. If there are objections, if you are unsatisfied with exceptions, please make those objections and I can rule accordingly. Thank you. You may proceed.
Ms. Donaldson, do you know why your father filed for that restraining order?
Yeah, right around that time was when he told Karen he wanted a divorce. She was so upset with that she threatened to kill him, and so he got the restraining order, or filed for the restraining order.
How long after that threat and the restraining order did your father disappear?
Like I said, it was only 2 short months later.
And do you know if he still wanted a divorce when he disappeared?
Yeah, he definitely did. I mean, there was more fighting just a few weeks before he disappeared. There was no plan changing. No.
Objection as to speculation as to he definitely did.
Your Honor, I believe you're muted.
Sorry, any response?
Your Honor, I am happy to lay foundation for why Ms. Donaldson knows that her father, in fact, wanted a restraining order and have that particular portion of her statement. He definitely did, stricken until that foundation has been laid.
I'm going to sustain the objection as to speculation, and I will strike that statement until further foundation can be laid. Again, counsel, if you have additional objections, you can make those.
Yes, Your Honor. Did you witness any other fights between your father and Karen in between the restraining order and his disappearance?
Yes, I did. There was a really big fight in the office. And again, I'm his assistant, so I sit right out front. It was about 2 weeks before he disappeared, and I heard him assert that he was going to file for divorce. And Karen went absolutely ballistic. You could hear her yelling through the wall. She stormed out. My father came out right after, visibly shaken. I mean, I'd never seen him like that.
Did you have a conversation with him at that point?
Yeah, well, he came out of the room and he looked at me and he told me that if anything ever happened, to have the police look into Karen. He was that fearful for his life again.
Objection, hearsay as to the statements of Lou Donaldson.
Your Honor, may I respond? Your Honor, I believe as Ms. Donaldson has stated this, we are not offering this as a statement for the truth of the matter asserted, which would make it hearsay. This is in fact an instruction from Mr. Donaldson to his daughter. As an offer of proof, she just said that if anything happens to me, tell the police to look into Karen. That is a command, not an assertion, and so cannot be hearsay.
Your Honor, you're still.
Your Honor, I believe.
I'm just going to leave it unmuted. Does the defense have one final response? I apologize.
Yes, Your Honor. A command, an assertion can absolutely have truth value. It's pretty clear that opposing counsel is using this statement for its asserted truth, that if he goes missing, that the police should look into Karen. There's multiple assertions that the plaintiff is making with this statement, Your Honor, but there's no exception that would allow such a statement, an out-of-court statement, to be brought in to today's proceedings.
Sorry, I'm thinking. I'm going to admit that particular statement for an instruction to his daughter, Ms. Donaldson, but I will issue a limiting instruction from the jury that this shall not be offered for the truth of the matter asserted in regards to any indication that her intent was to harm Mr. Donaldson, and that they can only use it for the limited purpose relating to the will.
Yes, Your Honor. Ms. Donaldson, did you get a chance to finish your answer?
Yes, I believe I did. Thank you.
So Ms. Donaldson, in that 2-month period after the restraining order and before your father disappeared.
Objection, Your Honor. Mischaracterizes the evidence under 403. May I be heard?
You may.
I guess may I approach the bench outside the presence of the jury? Your Honor,
yes.
For opposing counsel to reference on the record for the members of the jury to call this a restraining order mischaracterizes it for the jury. It was a request for a temporary restraining order, which was denied. So for her to refer to it, members of the jury could understand that there actually was a actionable restraining order against Ms. Beja, and that would mischaracterize the evidence.
And I'm assuming
yes,
and I'm assuming you're objecting under 403.
Yes, Your Honor.
Your response?
Your Honor, opposing counsel is right, and I should have called it a application of a restraining order. I do believe the jury, based on the fact that they heard that he had applied for a restraining order, would understand that was the event I was referring to, but I'm happy to restate the question.
Okay, I'm going to sustain the objection, and on the record, I will advise the jury to please disregard counsel's statements and to remember that counsel's statements are not evidence, and I will ask that you rephrase your question.
Yes, Your Honor. Ms. Donaldson, in the 2 months between your father applying for a restraining order and the time that he disappeared, did he say anything about wanting to change his will?
No, and he would have told me. I'm the one who kept his will locked up securely in my office.
In the 2 weeks between that fight that you overheard and your father disappearing, was there an appointment with a lawyer to change his will that you made for him?
No, and again, I kept his schedule. There was no appointment on the books.
I want to jump ahead a couple of weeks to the day you last saw your father. What happened that day?
Sorry, this is kind of hard to talk about, but it was the day before he was killed. It was just a normal day. I mean, he left the office around 6 p.m. It was a Friday. He told me that he would see me Monday unless I wanted to come over for dinner on Sunday. There was absolutely no mention of a trip to Costa Rica. I mean, how would that have even happened? I saw him on Friday. He invited me over to dinner on Sunday. There was nothing abnormal. I mean, I wish there was. I wish I could have done something differently.
What would you have done differently?
I would have hugged him. I would have held him, told him I loved him, and not let him go home. I would have done everything differently.
You mentioned earlier that your dad liked to travel, and you said there was no trip to Costa Rica, but did he mention any travel plans that weekend?
No, nothing at all. And he normally told me.
Did your father ever mention a girlfriend to you?
No,
As far as you know, was he ever unfaithful to Ms. Baja?
no, not that I know of, no.
Let's keep talking about that weekend. What's the next thing that stands out to you?
I mean, there was really nothing of note until Sunday morning at 6 a.m. The alarm at Wild Wildlife went off. So I rushed there immediately, and I live really close. And so I rushed over to see if I could catch whoever had set off the alarm.
What did you see when you got there?
Well, as soon as I got there, there's a gate that's normally padlocked into the entrance, and I noticed that the lock had been cleanly cut through. As soon as I entered the premises, I was able to see that the back entrance was destroyed, totally destroyed. And then it was about, 5 seconds later, the cops pulled up, and that's also when I saw Karen walking out of the office holding a lockbox.
I'd like to have the photos with Bates numbers ending in 004 and 005 marked as plaintiff's exhibits 1 and 2. Ms. Donaldson, do you have those particular photos in front of you?
Yes, I do.
What are they?
Well, the first one is the lock that was cleanly cut through, and the second one is the back entrance that had been destroyed.
Are they fair and accurate depictions of how the office appeared that morning?
Yes.
Plaintiff offers exhibits 1 and 2 in evidence.
Any objection?
No objection, Your Honor.
Plaintiff's exhibits 1 and 2 shall be admitted.
Your Honor, may I publish to the jury?
You may.
Ms. Bartos-O'Neill, will you display those photos, please? So, Ms. Donaldson, is this how the office appeared when you left on Friday?
No, definitely not.
You may stop sharing, Ms. Bartos-O'Neill. Did you recognize the lockbox Ms. Baja was carrying?
Yeah, I mean, it was the lockbox I kept under my desk that had my dad's will in it. It was in my office. I recognized it.
I'd like to have the document with Bates number ending in 0014 marked as Plaintiff's Exhibit 3. Ms. Donaldson, do you recognize the document I'm referring to? Is it in front of you?
Will be, yes.
What is this document?
This document is, well, it's not my father's will, but it is a will that I've seen before.
Is it a fair and accurate copy of that document?
Yes.
Plaintiff offers Exhibit 3 in evidence.
Any objection?
No objection, Your Honor.
Plaintiff's Exhibit 3 shall be admitted, and you have permission to publish if you'd like.
Thank you, Your Honor. Ms. Bartos O'Neill, will you share this document? Ms. Donaldson, is this the will that was kept in that lockbox?
No, it is not.
And were you aware of any plan of your father's to update his will?
Like I said, nope, there was nothing on the books, no appointment with a lawyer, absolutely nothing.
Ms. Bartos O'Neill, you may stop sharing. So let's keep talking about your father's disappearance. Do you know if an investigation ever happened?
Yes, there was an investigation. There was an investigation by the police. It was not very thorough, so I went ahead and hired my own private investigator.
Did they find any of your father's belongings?
Yeah, they found his van parked at a random airstrip 40 miles away with his glasses that he could not see without and his keys neatly tucked inside.
I'd like to have the photos with Bates numbers ending in 0013 and 0012 marked as Plaintiff's Exhibits 4 and 5. Ms. Donaldson, do you have those photos in front of you?
Yes, I do.
What are they?
They are pictures of my father's glasses and keys, as well as his van, picture of his van.
Are they fair and accurate depictions of your father's belongings?
Yes, they are.
Plaintiff offers Exhibits 4 and 5 in evidence.
Any objection?
No objection, Your Honor. We would just ask if opposing counsel could clarify, is 4 the glasses and keys and 5 is the van, or is that flip-flop, just for my records?
Let's have 4 be the glasses and keys and 5 be the van, if that works for you.
With no further objection, I will move to admit Plaintiff's Exhibit 4 and 5, and you may publish if you wish.
Ms. Bartos O'Neill, will you display the picture of the van? Where was this van found, Ms. Donaldson?
It was found 40 miles outside of town at a random airstrip that my father had never used, that he did not keep any of his planes at. That's where it was found.
Were you familiar with the hangar where it was found?
No, like I said, I had no reason to be familiar with it.
You may stop sharing, Ms. Bartos O'Neill. Ms. Donaldson, as your father's assistant, were you ever asked to access your father's accounts as part of any investigation?
Yeah, I was, and not a single penny of his money was spent after the day that he allegedly disappeared.
No further questions, Your Honor.
Any cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good evening, Ms. Donaldson. Can you see and hear me okay on your screen?
Yes, I can.
Your father owned airplanes, right?
Yes, like I said, that was one of his hobbies.
Like you said on direct, ma'am, your father, he knew how to fly those planes, right?
Yep.
He was a pilot, right, ma'am?
Yes, he was.
As a pilot, you're aware that sometimes your father, he would fly out of local airports, right?
Yes.
He would fly out of local airstrips, right?
Yep.
You're aware that sometimes your father would fly out of the country, right?
Yes.
Ma'am, you're aware that your father, well, sometimes he would fly over water, right?
Yes, and I knew that because he would tell me before he would leave, so I knew where he was going.
We'll get there in a moment, ma'am. I just need a yes to my question. You're aware your father, he flew over water sometimes, right?
Yes, I'm sure that he did in order to get where he was going.
Well, I want to talk about what happened on August 17th of 2012. Now, you remember that that was a Friday, right?
Yes, I do.
Your father, he was at the office that evening.
Yeah, he was. It was the last time I saw him.
It was the last time you saw your father was It was around 6 p.m. that night, right?
Yeah,
Miss Donaldson, your father, he didn't tell you where he was going when he left the office that day, right?
he told me he'd see me Sunday, but he did not tell me where he was going.
To be clear, you didn't know where he was going when he drove away that day, right?
There was no reason to. It was a normal day.
So, ma'am, that's a yes to my question. You didn't know where he was going?
No, I didn't know.
But
Definitively.
you do know, ma'am, your father, he owned a van, right?
Yep.
It's a blue van, right?
Yes, it is.
You don't know where he drove that van when he left that day, right?
I mean, I know it was nowhere of note because, again, he did not tell me where he was going. So
As
no,
you mentioned,
I didn't know.
yes, ma'am. But as you mentioned on direct, you do know that that same van, it was found at an airstrip, right?
A random airstrip very far away. Like you said yourself, counsel, he flew out of local airstrips. 40 miles away is hardly local.
You said it's very far away, ma'am. To be clear, it was 40 miles away from the office, right?
Much further than the other airstrips he used, yes.
That wasn't my question. That airstrip was 40 miles away from the office, right?
Yes, much farther than the other airstrips that he flew out of.
Well, I want to piece together what happened at that airstrip, Miss Donaldson. Now, as you testified on direct, your father actually owned multiple planes, right?
Yeah, he did. He really loved flying.
And as you testified, ma'am, he didn't always register those planes, did he?
I don't believe I testified to that.
Objection, Your Honor. This was not within the scope of direct, the registration of planes.
Your Honor, may I respond?
You may.
Your Honor, I'm happy to rephrase the question. I thought the witness testified to the extent that she knew where her father flew and that she knew he would log certain flights. I'm happy to rephrase the question.
I'm going to allow this line of questioning if this is within her statement that was provided as part of the case problem. I don't believe outside of the scope of direct is appropriate. Now, if it's outside of the scope of her statement that she gave within the packet, I will ask that the plaintiff can make an additional objection, but I will allow you to go down this line of questioning.
Yes, Your Honor. Miss Donaldson, you know that your father didn't always register the planes that he bought, right?
I know that he didn't always log flight plans. I am not sure as to whether or not he registered his planes. I'm sorry.
Well, let's be clear. Your father bought and sold planes all the time, right?
He owned planes.
That wasn't my question. Ma'am, you would say to the members of the jury that your father bought and sold planes all the time.
I know that he bought planes. I don't remember him selling planes all the time.
Ma'am, is it your testimony that your father never sold planes?
No, counsel, it's my testimony that he didn't sell planes all the time. I know that he owned planes, he bought planes, he just didn't sell them all the time.
I'm sorry if my question was confusing, ma'am. Your father bought and sold planes, yes or no?
I'm sure that at some point he bought and sold planes, yes.
Ma'am, you never knew exactly how many planes your father owned, did you?
No, but I always knew where he was going, when he was leaving, when he was coming back.
Again, ma'am, I just need you to answer the question that I'm asking you. And you didn't know exactly how many planes your father owned, right?
No, counsel, I didn't.
You can't tell the members of the jury if one of those planes went missing.
No, but I know my father and I know that that wasn't likely.
That may be the case, ma'am, but you can't tell the members of the jury if on August 17th, 2012, one of your father's planes went missing. You don't know that.
No, I wish I did. I want this to be over just as much as anyone else does. I wish I did, but no, I can't tell them that.
You can't tell the members of the jury if one of your father's planes is in the Gulf of Mexico right now?
Objection, Your Honor. I tried to object earlier and was not unmuted. My apologies. Your Honor, objection calls for speculation.
Any response?
Your Honor, this witness can testify to her knowledge. I'm asking her if she knows that, and based on her prior testimony, she doesn't know how many planes he had. She couldn't know if his plane was there, and that's the fact we're trying to elicit for the members of the jury. We're not asking her to unduly speculate or step outside of her own rationally based perception.
Your Honor, may I respond?
You may.
I would change my objection to lack of foundation. Counsel has just mentioned the Gulf of Mexico, and there has been no foundation laid for any trip over the Gulf of Mexico whatsoever with this witness.
And just remind me, I believe the question was, you don't know if your father's plane is in the Gulf of Mexico. Is that correct?
Your Honor, I ask you can't tell us if one of your father's planes is in the Gulf of Mexico right now.
I anticipate, based on the testimony here today, that this witness, and will be outside the presence of the jury, is going to potentially say, I don't know. If she speculates in regards to where she believes the plane is, I would ask that counsel lay additional foundation, but the witness is free to answer this particular question. So it's overruled.
Ms. Donaldson, you can't tell us if one of your father's planes is in the Gulf of Mexico right now, right?
I can tell you that one of his planes was not at that airstrip, as far as I know. So why would his plane be in the Gulf of Mexico? No, I can't tell you, but no.
Now, Ms. Donaldson, you're aware that pilots, they're supposed to log their flights with a local airstrip, right?
Yes, I'm aware.
And as you mentioned, you know that your father didn't always log those flights, right?
That's correct, yeah. But I always knew where he was going. He logged them with me, but no, not formally.
In other words, ma'am, sometimes your father would take off from an airstrip without telling anyone at that airstrip, right?
I believe that's what that means, yes.
To your knowledge, your father, before August of 2012, had never been in a plane crash, right?
No, he had not.
To your knowledge, ma'am, before August of 2012, your father had never flown without his glasses. True?
True, he could not see without his glasses. He wouldn't have been able to drive to that airstrip without his glasses. I know he only had one pair. He would not, on his own accord, have gotten out of that van without his glasses on.
So, ma'am, you agree with me that your father, prior to that date, he had never flown without his glasses, right?
He had never driven without his glasses. He had never flown without his glasses. He had never grocery shopped without his glasses. He had never been in the office without his glasses. He could not see without his glasses.
So that's a yes to my question.
It's an absolute yes to your question.
You're aware that your father would often fly alone.
Yes.
When your father disappeared, ma'am, he was in his 60s, right?
Yeah, and smart as a whip. I mean, look at the company he created, the foundation he was able to maintain. He was in his 60s, but in his prime.
Ma'am, best of your knowledge, no one has found your father's body, right?
No.
Let's talk about your claim against Miss Beja today. Now, on August 17th of 2012, you didn't see Miss Beja shoot your father, right?
On August 17th? No, I don't remember seeing Miss Beja. I said goodbye to my dad for the last time.
You didn't see Miss Beja disposing of a body on that day, right?
No. No.
In fact, ma'am, you didn't see Miss Beja and your father together at all that weekend, right?
No. Together, no, but I saw her at the office breaking into her own office to steal something.
Well, let's talk about that, ma'am. You claim that Miss Beja broke into an office and stole a lockbox. Do I have that right?
There was a lock cut, there was a back entrance destroyed, there was an alarm that went off, and there was Miss Beja walking out with my father's will in a lockbox. Yeah, I would call that stealing, or a very strange way of getting into your own office.
So let's break that down for the members of the jury. You're telling us that Karen Beja was there, right?
Yes,
You're telling us that there were multiple policemen there, right?
yes, and there was some weird guy there with her too.
So there was
helping her.
there was someone helping Miss Beja. Do I have that right?
Yes,
There was at least one police officer,
yes,
and there was you, right?
yes, yes.
Miss Beja, only one of those 4 people is on your witness list today.
Is that a question? Yes, because the very next day she reported him missing. So why wouldn't I be concerned about that?
That's a yes to my question.
Nobody knew he was missing, and she reported him missing the next day after breaking into her office. Yeah,
Again,
she's the only one on my witness list.
Ma'am, I understand you might want to explain your answers. In a moment, opposing counsel will come up here, give you a chance to explain them. But for now, I just need a yes or a no to my questions. And you would testify that you are the only person of those 4 people on your witness list today.
I apologize, counsel. This is hard for me to talk about, but I'm not on my witness list. Miss Beja is, but yes.
You're
Ms. Beja's
testifying
on my
here in
witness
court,
list.
right, ma'am?
Yes.
Now, you say that the alarm went off. You don't have any records from the alarm company, do you, ma'am?
Any records? Not with me, no.
You said that police were there. You don't have any police reports that you brought to court today, right?
No, I don't.
So then let's talk about why you brought this lawsuit. Now, Ms. Donaldson, you hired a private investigator to investigate your father's disappearance, true?
True.
You didn't hire a private investigator a week after your father disappeared, right?
Right.
You didn't hire a private investigator a year after your father disappeared, right, ma'am?
Right. I mean, it wasn't until later that I came to my senses and realized the police needed a second go around. I needed somebody else to do my father's work. I mean, there was no one speaking for him. So it took a little while, counsel, but I got there.
Took you a while to come to your senses, so you didn't hire anyone until your father had been missing for 5 years. Right, Miss Donaldson?
I mean, I guess in a way I was kind of holding out hope, but once Karen finally had him legally declared dead, I had to face the facts. I mean, it's not something you want to admit, but yeah, once that was legal, once he was legally pronounced dead, you bet I had somebody go do that, go look into it. I didn't get answers.
That's right, ma'am. You didn't hire anyone to investigate your father's disappearance until Miss Beja was about to inherit his entire estate. True?
I did not hire anybody until after he was declared legally dead because I wanted answers.
Well, let's be clear about that, ma'am. You hired someone in June of 2017, right, ma'am?
I hired someone in June of 2017?
Taylor Pride.
Yes.
And
Yes, I
Miss
did.
Beja, she had Lou declared legally dead in August after that, right?
Yes, I guess it was official after that.
All right, ma'am. Now, before your father disappeared, you thought you were in his will.
I was in his will. I saw it. I kept it locked up. I was in his will.
Before your father disappeared, you thought you were in line to inherit a quarter of his estate, right?
Yes, I was.
Miss Donaldson, Miss Beja, she showed up with a will that left everything to her. Right?
Yes, she did, but it seems like you're implying that the money is what I'm upset about. It's not. It's that she stole from my father.
Ma'am, I just need a yes or no to my questions. Miss Beja produced a will that left her everything, right?
Yes, a will, not my father's.
So you haven't recovered a penny of your father's fortune. Is that true?
That's true.
You'd like that money. Isn't that true, Miss Donaldson?
Yeah, I suppose I would, but that's not why I'm here, counsel.
Thank you, Miss Donaldson. Your Honor, I have no further questions at this time.
Thank you. Is there any redirect?
Very briefly, Your Honor. Ms. Donaldson, the last time you saw your father, did he tell you anything to indicate he planned to travel that weekend?
Nothing at all. Like I said, it was a totally normal day. He told me that he would see me Monday unless I wanted to come over to dinner on Sunday. I mean, I guess in a strange world where my dad wasn't my dad, I mean, he normally told me where he was going. I suppose he could have planned a day trip on Saturday, but again, he would have told me, and it would have been a day trip, nothing involving flying over the Gulf of Mexico.
Now, Ms. Donaldson, Mr. Trevisani asked you about the original will and how much you stood to inherit. What was the original makeup of that will?
Well, 25% of that will was going to go to a foundation to keep wild wildlife alive. It was, again, it was my father's passion. 25% was going to go to Karen, and 25% was going to go to me. I can't remember off the top of my head. I'm going to look at that exhibit very quickly.
Would you like to refresh your memory with a copy of your deposition?
Yes, I would.
Let me know when you're ready.
I apologize.
Was it to your biological mother, Ms. Donaldson?
Yes, I believe it was. I didn't want to misspeak, but that was my assumption, or not my assumption, my recollection was that the last quarter went to my mom. They had a really great relationship, even with the divorce. My dad was very amicable. They were very amicable. He was the type of man that wanted to take care of his family, his whole family. And like I said, 25% was allocated to wild wildlife, 25 for Karen, 25 for me, 25 for my mom. I mean, that just perfectly encapsulates who my dad was and how he spent his money. That was
Why
my
are you
dad's
here?
will.
Thank you. Why are you here today, Ms. Donaldson?
I'm here to get my father's desires reinstalled. I want his last will, his true last will and testament, to be what lives on. His legacy, caring for his family, it's his. He built it all himself. He deserves to have that money spent the way he truly wanted it spent.
No further questions, Your Honor. We ask that this witness be excused.
Thank you. This witness may be excused. Do the plaintiffs have any additional witnesses that they would like to call in their case in chief?
Yes, we do, Your Honor. But before I do, on this next witness that I intend to call, Taylor Pride, we intend to offer the request for the temporary restraining order. May I approach to discuss the admittance of that exhibit at this time?
Yes, you may.
Now, Your Honor, we do intend to offer this exhibit, the request for the restraining order on Taylor Pride. And it is my understanding that your only concerns at this point are a 403 and 404 objection from opposing counsel rather than the hearsay.
I am concerned with hearsay now that I have a better grasp as to why the parties are intending to admit this. It's my understanding that these are written statements from Mr. Donaldson, who is not a party in this case. And my concern without seeing the actual document and the statements is that not only are they hearsay, but that the content would be 403 and 404.
Of course, Your Honor, and I'm prepared to answer on each of those grounds at this point, if you'd like.
Sure.
So, Your Honor, first beginning with the hearsay. We believe that this document falls under an exception to hearsay 8033 state of mind, specifically to Mr. Donaldson's state of mind. The statements, if I may make an offer of proof for the statements of this.
That would be helpful, yes.
He specifically states the three statements of concern. I do not feel safe around Karen Baja. I am seeking a divorce from Karen Baja, and Karen Baja, the defendant, has threatened to kill me. The part where the statement from Karen Baja, that would be a party opponent, but the remainder of the statements indicate Mr. Donaldson's state of mind, his fear, as well as his intent and plan to divorce Ms. Baja. This indicates and would fall under that exception. May I move on to ER 403 and 404, or shall I wait for opposing counsel to respond?
If you could just make your full argument, that would be wonderful.
Yes, Your Honor. As for the concerns with Evidence Rule 404, first of all, these particular statements don't indicate a trait on behalf of Ms. Baja and therefore wouldn't actually fall under 404. But furthermore, even if you were to treat this as a propensity, it would fall under 404B2 as a permissible use, as these particular statements indicate potential intent and motive for Ms. Baja, or excuse me, Ms. Baja to be motivated to get rid of her husband with the intention of gaining his property and maintaining her lifestyle. As for 403, there are several reasons why this particular document and the statements within are relevant in such a way that it outweighs its prejudicial value. For one, as I mentioned before several times, it indicates motive and intent on behalf of Ms. Baja for a reason why she might want to get rid of Mr. Donaldson, as it is part of our burden to prove the element that her conduct caused Mr. Donaldson's death for a disappearance or potential death that happened over 8 years ago. This evidence would go to that particular point. Furthermore, Taylor Pride will testify that the contents of this document, as well as the date attached to it, June 12, 2012, indicates that the provides suspicious circumstances for the will that Ms. Baja presents just 2 days later. The Taylor Pride will testify that these circumstances were highly suspicious and would go to the fact that the will that Ms. Baja presented that left her everything of Mr. Donaldson's property is indeed fraudulent. And therefore, for all of those reasons, the probative value would substantially outweigh any prejudicial effect. And at this point, we're also willing to admit the document as a whole, including the denied stamp, if opposing counsel is concerned that that would further the prejudicial value on the jury.
One question. So the first statement is in regards to their divorce. And then I also have the statement that she was going to kill me. Can you remind me what the third statement that you're seeking to admit?
Yes, Your Honor. The third statement is, I do not feel safe around Karen Baja.
And I don't need to hear from defense. I think that this was addressed in motions in limine. And now that I've had an opportunity to hear a portion of the state, I am going to deny the request at this time to admit the document. I do not believe that the statements that are attempting to be elicited would fall under 8033. These statements are when admitted to go to a state of mind such as motive, intent, or plan. These appear to be statements in regards to the decedent not feeling safe, which would not be a motive, intent, or plan. That she is going to kill me, I don't think falls again under the then existing mental state of a motive, intent, or plan, nor does it indicate any type of sensory or physical condition in which he is, in which you are attempting to admit it. There already has been statements that he wanted to get a temporary restraining order applied for one due to the divorce. So I will allow you to question that since that has already been admitted. But I find that these statements, not only are they hearsay, but I am concerned that these statements would be used to prove that the defendant in this case did commit these crimes versus the admitted purpose of his mental state or why he sought the protection order. I think they will go to the ultimate issues of the case, which is for the jury to decide. So I'm going to deny that request, and I will not allow admittance of that particular piece of evidence. So you may proceed.
Yes, Your Honor. We call Taylor Pride. Good evening, Ms. Pride.
Good evening.
Would you please introduce yourself and spell your last name for the court?
Sure. My name is Taylor Pride, and my last name is spelled Pride.
What is your role in this case?
Well, I'm a private investigator, so I investigated the evidence in this case.
What were you hired to look into?
Well, I was hired by Cam Donaldson to look into her father's alleged disappearance.
And did you also look into a will?
Yes, a part of that.
Were you able to form conclusions on those two things that you looked at?
Yes, I have.
Before we get to the details of your conclusions, I want to talk to you about your training and experience. What's your current job?
Well, as I mentioned, I'm a private investigator, and I'm currently self-employed at Pride Investigations Incorporated.
And what did you do before you were a private investigator?
Before that, I worked for Pioneer PD in 1998. I briefly worked as a patrol officer, but then I was quickly hired as a detective in 2020, in 2000, and then I left in 2016.
And while you were a detective, what kind of things did you investigate?
I investigated a lot of things across the board, from economic crime to homicides, lots of things.
And you mentioned that you also investigated economic crimes as a detective. How many years did you do that?
I believe I investigated from 2002 until 2008. So, that time period.
And could you give us an example of what an economic crime is?
Sure. Fraud, tax evasion, things like that.
And do you have any kind of educational background in economic crimes?
I do. Like I said, worked on the force and economic crimes specifically. And a part of the economic crimes is analyzing signatures, handwritings, things like that. And I have attended conferences from the American Association of Handwriting Analysis. I've also attended things from the American Board of Forensic Document Examiners. So a lot of education.
You mentioned that the American Board of Forensic Document Examiners. Are you certified with them?
I am, yeah. I had to go through 4 phases in order to become certified, but through the testing and my credentials, I was eventually admitted.
How do you keep up to date with developments in economic crime and handwriting analysis?
Well, it's no small task, but I attend a conference annually. I study literature, obviously, and I do recertify through the American Board about every 4 years.
Now, before we talk about the details of your investigation and your analysis, I want to talk to you about your methods. Now, are you familiar with the methods that detectives would use when they're conducting an investigation?
Yes, I was a detective, so I would say I'm familiar.
And did you use that method in today's case?
I did.
I want to talk to you about your methods for document examinations. Do you have a standard method for that?
Yeah, it's a 3-step method that I use.
Could you briefly describe what those 3 steps are?
Sure. Just briefly, I will, gather some samples of their handwriting, and I'll take those samples and kind of look at the differences between them and create kind of a fingerprint, if you will, of their signature. And using that fingerprint, I will, compare it to other handwritings in question.
And did you use that 3-step analysis in today's case when you were looking at the will?
Yes, I did.
Now, what kinds of documents did you review, if any, in the course of your investigation and analysis?
Sure. I investigated a few different things. I investigated a license, the signature on his license. Through the DMV, I investigated the will. I investigated a written letter from from Mr. Donaldson he gave to his son.
And did you, in the course of the documents that you reviewed, did you also look at an application for a temporary restraining order?
I did, yes. I looked at the application.
Your Honor, at this time, we would like to tender Ms. Pride as an expert in investigations and document examination.
Any objection or voir dire?
No objections, Your Honor, as to expertise in document examination, but as to investigations as a whole, that's a very broad field, and I don't believe that opposing counsel has laid the foundation that this witness is an expert in all and any investigations.
Your Honor,
Any response?
may I clarify? I apologize. I was specifically referring to investigations into the documents for document examination purposes. If I may make a small offer of proof, Ms. Pride will have reviewed documents outside of the will and signatures in order to inform her opinion on whether or not that the will was valid. So that's simply what I was referring to.
I'm going to move to admit Investigator Pride as an expert in document investigation and document examination pursuant to 702. You may proceed.
Yes, Your Honor. Okay, Ms. Pride, I want to talk to you about the will that you analyzed. Now, you mentioned that you looked at several samples of Mr. Donaldson's signatures. What value did you have in looking at other documents outside of those signatures?
I mean, really not too much. I mean, you take a few signatures and kind of gather the fingerprint from there, so.
Well, specifically, Ms. Pride, did the date on the application for the request for the restraining order indicate anything to you about the validity of the will?
Sure, yeah. The date in question was, I believe, June 12th, and the will was June 14th. So that seemed like a very small window, the 2-day period between the application for the restraining order versus the will that was executed.
Okay, Ms. Pride, I now want to talk to you about the signature on the will. Now, how many samples of Mr. Donaldson's did you have available to you?
I think about 3.
And what did you find when you were comparing those samples of Mr. Donaldson's signature to the one on the will?
I'm sorry, can you repeat the question?
Yes. What did you find when you were comparing Mr. Donaldson's sample signatures to the one on the will?
Well, I found that they were just not very similar. I mean, in the ones from the signatures, there were certain letters like a lazy O and other certain details that really matched up. But then when I compared it to the will, I mean, I could see that all of the signs of forgery were kind of present. There was really, in the D, 2 different lines, big spaces, a lot of quivering, all signs that, in my experience, would lead to me to believe it was forged.
Well, Ms. Pratt, I want to talk to you about the other parts of the will outside of the signature. And I'm going to ask Ms. Parman to share her screen with the will that's been entered as Exhibit 3. Just wait a couple of moments to have Ms. Parman get adjusted. Thank you, Ms. Parman. Okay, Ms. Pride, this document was the will you reviewed, right?
It was.
Now, could you tell us a bit about what these other signatures are on the will?
Sure. Those are the signatures of the witnesses to this will.
In your experience of examining documents, what are the purposes? Why do wills like these have witnesses?
Sure. I mean, it's common that, wills are contested often. And so you want to make sure, you dot your I's, cross your T's, and that your witnesses are there to actually view so they can attest, yes, the person in question did sign this document and this was their wishes.
And who were the two witnesses for this will?
Sure. As you can see here, Samantha Lane was one of the witnesses, as well as as Mr. Donaldson's wife, Karen Baja.
In your experience as a document examiner, did it concern you at all that Ms. Baja, excuse me, signed this will or signed as a witness to this will?
Yes, I mean, I think that anyone who is a primary beneficiary of the document begs a credibility issue.
And did you find any issue with the second witness?
Yes, I actually spoke with Miss Lane, and she said that
Objection, Your Honor. Hearsay as to any statements by Miss Lane.
Your Honor, may I
Any-
respond and
You-
approach?
Yes.
Your Honor, if I may make an offer of proof of the Ms. Lane statements that we intend to offer in order to clarify.
Sure.
We believe that Ms. Pride is about to testify that Ms. Lane told her in a phone call that she was coerced by Ms. Baja, specifically with the threat, "I'll feed you to the kitties," into signing this document. Those statements by Samantha Lane would come under unavailable witness 804, and specifically 804B, statement against interest, as Ms. Lane signing this, having not actually witnessed Mr. Donaldson sign it, would be perpetuating a fraud, which would be a statement against interest for her as an unavailable witness. And furthermore, as we've discussed many times before, the specific threat from Karen Baja would be a statement by a party opponent.
Any response?
Yes, Your Honor. We don't disagree. The statement by Miss Baja herself would be a statement by the party opponent, but any statement by Miss Lane is still hearsay. There's two levels of hearsay here. As to the defense's contention that Samantha Lane is an unavailable witness, first off, that's not true. Both parties here stipulated as to which witnesses were unavailable for trial, and they were Exotic Bob and and Miss Baja's brother. Nobody stipulated that this witness, or rather, sorry, that Samantha Lane was unavailable for trial. Opposing counsel simply didn't call them as a witness. They're not on their witness list. Secondly, Your Honor, as to the argument that this would be a statement against interest, this is not a trial for Samantha Lane and whether she did or did not examine this will and see Lou Donaldson sign it. This is a trial which the plaintiff has brought against Karen Baja. This would be inadmissible under Rule 403 is substantially more prejudicial than probative. Any statements that come in from Miss Baja would be incredibly prejudicial, and the probative value that they're bringing up is simply that Samantha Lane may or may not have seen this be signed.
I'm pulling up 804. I believe 804 is a two-part test. The first part of the test is that the witness is unavailable, and since there is not a stipulation within the case problem or between the parties regarding this witness, can you please give me an offer of proof or explain to me which exception under 804 subsection A that you are seeking to admit that for unavailability?
Your Honor, we believe, if making an offer of proof, that there will be testimony later in trial indicating that Samantha Lane is indeed unavailable by the fact that when subsequent witnesses tried to reach out to her to follow up on conversations, she was unable to, she couldn't be found. And for that nature, she was unavailable. We are happy to let this particular testimony of Ms. Pride come in conditionally on the fact that that foundation later gets laid with a different witness.
In one moment. Um, in your offer of proof as to whether or not she is available, what I'm considering based on your offer of proof is under 804 subsection A, subsection B, which discusses that a proponent may not be available by process or other reasonable means to produce. And it's whether or not they're in attendance, and then it refers to subsection B1 or B6. I think B6 would apply, but it has to be that the offered against a party that wrongfully caused the declarant's unavailability. I don't see that there's simply an exception that just because you couldn't find the witness, that this exception would apply. Is there any indication in your offer of proof that the defendant in this case has caused the unavailability of this particular witness?
Your Honor, we do not have testimony or evidence of that.
Based on the fact that I don't believe that there's enough foundation to lay in regards to this witness being unavailable, I'm going to sustain defense's objection.
Yes, Your Honor. Now, Ms. Pride, was there anything about the content of this will that concerned you?
I think that besides the signature issue, the word disappear specifically is concerning and odd in a will.
Do you see that phrase, die or disappear, or the mention of a disappearance in wills that you've examined in the past?
In my experience, I have not seen disappear as a triggering word. Normally, it's just death.
And based on your analysis of the content of this will and the signature, what were you able to conclude about this document?
I was able to conclude that it was indeed a forgery.
Thank you, Ms. Pride. We have no further questions at this time. And Ms. Parman, you can stop your screen share. Thank you.
Thank you. Any cross-examination?
Yes, Your Honor. May I proceed?
Yes, you may.
Good evening.
Hello.
I want to start off by talking about whether a crime was even committed in this case. You are a private investigator, right?
That's correct.
And you were hired by the plaintiff, Cam Donaldson.
That's correct.
She hired you to look into Lou Donaldson's disappearance.
Yes.
Now, you used to be a police detective, right?
Yeah, for 16 years. Mm-hmm.
So with 16 years as a police detective, you have experience collecting evidence, right?
Yes.
You know that evidence can include eyewitness evidence.
Sure. Yes.
You know it can include physical evidence.
Yes.
Let's talk about the eyewitness evidence you found in this case. You didn't speak to anyone who saw Karen Beja kill her husband.
No. There was
You didn't just
Sorry.
You didn't discover any eyewitness evidence of Karen Beja disposing of her husband's body.
I didn't.
In fact, you didn't find a single eyewitness who even saw Miss Beja with her husband the weekend that he disappeared.
Not that I recall.
So that's a no. You didn't find a single eyewitness who saw Miss Beja with her husband the weekend he disappeared.
No, not on the weekend.
Let's talk about the physical evidence that you found then. You didn't find any blood at Miss Beja's home.
I didn't find any blood, no.
You didn't find any blood at all that linked Miss Beja with her husband's disappearance.
Right. I mean, I was the private investigator years later, so.
Okay, but you didn't hear from anyone who discovered blood that linked Miss Beja with her husband's disappearance.
I did not hear from anyone, no.
You didn't talk to anyone who found skin that linked Miss Beja with her husband's disappearance.
No, I didn't find skin.
No hair?
I didn't find hair, no.
No DNA?
No, I didn't find his DNA.
No fingerprints?
No, I wasn't looking for his fingerprints.
Now, as a former detective, you're familiar with the term crime scene, right?
Yes.
That's where a crime took place.
Yes.
You can't tell us where the crime scene supposedly was in this case.
No, I guess. Nope.
You can't tell us where Miss Beja supposedly killed her husband.
No.
As a former detective, you're also familiar with the term murder weapon.
Yes, I am.
That's the object used to kill someone.
Mm-hmm.
That's
Yeah.
a yes?
Yes.
But you didn't find the supposed murder weapon in this case, did you?
No, I think that Miss Baja would have made sure to get rid of it by then.
I'm not asking what you think. I'm asking what you found. And you didn't find the murder weapon, right?
No.
You also can't tell us what the murder weapon supposedly was.
I don't know what the murder weapon was.
Now, Lou Donaldson, he was declared dead in 2017, right?
Yes.
But that's not because he was found dead, is it?
His body was not found, no.
That's right. His body has never been recovered, right?
Right.
In the last 8 years.
Yes, there was no body.
Now, you spoke to some police investigators as part of your own investigation, right?
Yes.
You didn't find that Miss Beja's ever been arrested, right?
No, I mean, I know her brother worked on the force, so I think that.
I'm not asking where Miss Beja's brother worked. I'm asking about your investigation into Lou Donaldson's disappearance. And you did not find that the sheriff's department ever arrested or charged Miss Beja, right?
I didn't find that he arrested her, and I didn't find that he charged her, no.
In fact, you didn't find that the sheriff's department has ever arrested anyone in this case.
Yes.
So let's talk about a second possibility. You know that Lou Donaldson used to fly to Costa Rica, right?
Sure, yeah, many places, including Costa Rica.
But when he flew to many places, including Costa Rica, he didn't fly commercial, did he?
No, he had small planes.
That's right, he was a pilot.
Correct.
He owned his own planes?
Mhm.
He flew his own planes.
Yes.
His van was found next to an airstrip, right?
Yes, next to an airstrip with his glasses and other belongings.
That's right, in the front seat of Lou Donaldson's van, when it was found at an airstrip, were his glasses? Is that a yes?
Yes, like I said.
Now, you sent someone to Costa Rica to look for Lou Donaldson's, right?
Yes, I did.
But it's true that between here and Costa Rica, that's 2,200 miles, right?
Yes, that sounds right.
You didn't send anyone to investigate those 2,200 miles.
I sent someone to Costa Rica. You wanted me to investigate every inch between there?
It's not what I wanted. I'm asking what you did as part of your investigation. And you didn't send someone to investigate the 2,200-mile stretch between here and Costa Rica, did you?
No, I didn't send someone to look at 22,000 miles.
Well, you also didn't investigate whether there were any small plane crashes in that 2,200-mile stretch the weekend Lou Donaldson disappeared.
Objection, Your Honor, to lack of foundation and more prejudicial than probative under evidence rule 403.
Any response?
Your Honor, as to the foundation, this is the witness who coordinated this investigation. I think the foundation has certainly been laid. And as to more prejudicial than probative, this is incredibly probative, Your Honor. This witness has testified as to her belief and is testifying on behalf of the plaintiff that Karen Beja killed her husband, that she never performed an investigation of the area that he would have flown over is very probative. And there's no prejudicial value here at all, Your Honor. There's no prejudice that this witness didn't complete their investigation and look at that space.
I'm going to No, I'm going to overrule the objection. You may proceed.
Yes, Your Honor.
So, Ms. Pride, you didn't investigate the number of small plane crashes that occurred in that 2,200-mile stretch the weekend that Lou Donaldson disappeared.
I did not do that. No.
You can't tell us if there were any abnormal weather patterns in that 2,200-mile stretch that weekend.
No.
Lou Donaldson, he owned multiple planes, right?
Yes. Mhm.
So you can't actually tell us if one of his planes was missing the same weekend he disappeared.
I can't, no.
No further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor. Ms. Pride, on cross-examination, Mr. Ayers asked you about Costa Rica and searching the ocean from here to Costa Rica. Why didn't you look through that entire distance?
I mean, to be honest, a lot of that's ocean, and did he want me to get a scuba gear? I'm not sure.
Was the focus of your investigation looking into Mr. Donaldson's planes or where he might have gone?
It wasn't. It was the odd circumstances surrounding his disappearance, including the word disappearance in the forged will.
On cross-examination, Mr. Ayers also asked you about the police investigation. How long ago did that police investigation occur?
About 20 years ago.
Ms. Pride, was the investigation into Mr. Donaldson's disappearance in 2012?
Yes, it was. Excuse me.
Now, was it the focus of your investigation? Was the focus of your investigation to find a crime scene?
It wasn't. No, that was not what I was hired to do.
Was the focus of your investigation to find a murder weapon of any kind?
No, like I said, I was hired for my specialties, which was economic crimes, signature analysis.
Thank you, Ms. Pride. We have no further questions.
Thank you. I know that we are scheduled to take a break, but before the break, is there any Rule 29 motions that either side would like to make?
Actually, Your Honor, I apologize. Before we close our case in chief, we would actually like to read onto the record the testimony of Exotic Bob, specifically and limited only to the statements that were said by Karen Baja.
I apologize. Yes, you have permission to read those statements into the record.
She said, Exotic Bob, I swear if you double cross me on this deal, I will do to you exactly as I did to my husband. There won't be no disappearance, no mythical flight to Costa Rica. Your last supper will be you. I'll feed you to my kitties just like I did him.
Thank you.
And I apologize. One more note. Before we rest or close our case in chief, we do want it to be stipulated and noted that that within the nature of our jurisdiction for this particular case, that the defense is going to be calling Karen Baja in their case in chief. If we had it any differently due to the rules of the jurisdiction, we would have actually called Ms. Baja in our case in chief. And we want that specifically noted in relation to any potential motions for directed verdict that defense may make.
Okay, that is noted. Do you have any additional witnesses or statements that you would like to read into the record?
No, we don't, Your Honor. At this time, we'll close our case in chief.
Thank you. And are there any motions that we would like to make before halftime?
Yes, Your Honor. We move for a judgment as a matter of law under Rule 50 of the Federal Rules of Civil Procedure. Even under the light most favorable to the non-moving party, no reasonable jury could find the plaintiff has met their burden here. They had to prove by a preponderance of the evidence that Ms. Baja killed her husband, and they have no proof of this accusation. There's no direct evidence, there's no eyewitnesses. We realize that parties are allowed to use circumstantial evidence as well, but they failed here too. They have provided no physical evidence at all. No blood, no DNA, no body, no fingerprints, nothing. The only thing that their expert concluded was about the signature on a will, but this isn't a forgery or probate case, it's a wrongful death case. So we move for judgment as a matter of law.
Any response?
Yes, Your Honor. We ask that you do not grant defense's motion to close this case as a matter of law, as we do have significant evidence, specifically circumstantial evidence, to support the fact that Ms. Bajo is legally responsible for Mr. Donaldson's death. Now, we want to be clear that the burden of proof in today's case is not beyond a reasonable doubt. It's a preponderance of the evidence. And furthermore, because Mr. Donaldson's death, or disappearance rather, occurred over 8 years ago, it is only natural that no DNA, no blood, or the nature of a crime scene would be present anymore. However, there are other pieces of evidence to indicate that Ms. Baja's conduct caused Mr. Donaldson's death. Namely, we have the confession as relayed by Bob about how she said to him that that there will be no mythical disappearance or flight to Costa Rica, and that she would have fed Exotic Bob to her cats, just as she did with her husband. Furthermore, we have evidence that Ms. Baja could have been potentially motivated by the fact that Mr. Donaldson, just 2 months before his disappearance, had wanted to divorce her. We also have testimony on the following day after he was declared missing from Ms. Cam Donaldson, indicating that a break into a lockbox where Mr. Donaldson's old will was. And in addition to the fact that the will that was presented when Mr. Donaldson was declared dead was fraudulent, according to Taylor Pride, all indicates is circumstantial evidence and motivation for the fact that Ms. Donaldson may have caused Mr. Donaldson's death. Furthermore, of course, pending Ms. Baja's testimony that we have not yet heard, we believe that her testimony will also reveal pieces of evidence concerning her lack of alibi for the time period that Mr. Donaldson would have been killed or disappeared during, in addition to the suspicious circumstances of the will.
Thank you both for those arguments. At this time, I do believe that the plaintiffs have put on enough evidence to meet their burden under Rule 50, and I'm going to deny defense's motion at this time. I think now is, unless the parties have any additional information that they would like to provide the court on their cases, I do think that now would be a good time for the 5-minute break. Is that still what both parties are requesting?
Yes, Your Honor.
Okay.
Yes, ma'am.
Perfect. So it is 8:05. Do the parties want 5 minutes, or would they prefer 10 minutes?
5 minutes works for me.
So then let's reconvene here at 8:10. I will just mute the screens and then also mute everyone's mic so that if you guys need to have conversations on the phone, you're in the privacy to do that. And we will see you back here at 8:10.
Thank you, Your Honor.
All right, do we have all the parties back and the witnesses? And do we have both of the scoring judges, Bobby and Tracy?
Yes, Your Honor.
Perfect. And are the parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Wonderful. We will begin by allowing defense to present their case. Do you have any witnesses that you would like to call?
Yes, Your Honor. The defense calls Miss Karen Beja to the stand. May I proceed, Your Honor?
You may.
Good evening. Can you see and hear me okay on your screen, ma'am?
Yes, sir.
Please introduce yourself to the members of the jury.
Hello, my name is Karen Beja.
What do you do for a living?
I work at Wild Animal Sanctuary, sir.
When did you meet a person named Lou Donaldson?
I met him 20 years ago.
How did you and Lou meet?
Well, I was hitchhiking and he stopped. I figured he was just a nice guy, but I didn't know he was going to be my soulmate.
Were you and Lou married?
Yes, we married in 2001.
Walk us through that marriage. What did you and Lou like to do together?
Well, we had a shared passion for animals, especially tigers. We spend most of our time building and growing our animal sanctuary.
How would you describe your relationship with your husband?
Well, I loved him. Our marriage had its ups and downs. All marriages do, but I loved him with all my heart.
Miss Beja, did you kill your husband?
Absolutely not.
Did you dispose of your husband's body?
No. I don't know what happened to Lou. All I can say is I had nothing to do with it.
Let's talk about what might have happened to your husband. Now, how many planes, to the best of your knowledge, did your husband own?
Lou had several planes. I can't even tell you how many.
Where would he fly?
Mostly to Central America, Costa Rica.
When Lou would fly,
And I
would he
apologize.
ever take any?
I apologize. I'm going to interrupt for 1 second. It looks like your video is frozen on my end. And I cannot.
Agreed.
Yeah, and I want to make sure that we can see you.
Hi there.
Oh, you're back a little bit, but you're frozen.
Your Honor, can you hear me? Can you see me?
I can hear you, but it looks to just be a frozen picture of you. So your voice is coming across, but your picture is frozen.
Your Honor, can you hear me?
I can hear you.
Am
I
I-
just still can't see you. I don't know if it's an internet connection.
Can you see or hear me right now, Your Honor?
I could hear you, but again, your picture is just frozen.
Your Honor, if I may, just 1 minute, if I can just disconnect and reconnect and change the source of my connection, I can use a hotspot instead of Wi-Fi. If Your Honor will just wait just a few minutes.
Absolutely. You can take your time.
Thank
Your Honor, I believe he's in the waiting room.
Thank you for letting me know.
Your Honor,
Yes, you're back.
can you see and hear me?
I can.
Your Honor, I apologize. I'm not sure what went wrong, but I appear to be reconnected.
Yes, no need to apologize, and you can proceed whenever you're ready.
Thank you. I appreciate that. Just 1 moment. Miss Beja, are you still there?
I am, yes.
I apologize, ma'am. I think I was asking you about your husband's planes. Could you tell the members of the jury, to the best of your knowledge, how many planes did your husband have?
Lou had several planes, but I wouldn't be able to tell you how many exactly.
When Lou would fly, where would he go?
He would mostly go to Central America, Costa Rica.
And when Lou would fly on these trips, do you know if he ever took anyone with him?
Lou would fly solo.
And when your husband would fly, would he ever tell you beforehand?
Almost never. He would just go. I would only find out later that he'd landed someplace or that he'd come home.
Miss Beja, when was it that your husband disappeared?
That was August 17th, 2012. He drove to the office that morning and I never saw him again.
Well, I want to talk about that. Miss Beja, if you could open up, I believe it's attachment 4 to your deposition, and let us know when you have it on your screen.
Yes, I have it here.
Do you recognize this photograph?
Yes, this is Lou's van. It was an '89 Dodge Ram.
Your Honor, permission to publish this exhibit on screen for the members of the jury. It's already been entered into evidence as Plaintiff Exhibit 5, I believe.
You may publish.
Can you see that okay, Miss Beja?
Yes, I can.
So after your husband disappeared, when was the next time that you saw this van?
I saw it a week later on August 25th.
Where was it?
It was at an airstrip about 40 miles from here.
I want to talk about what was inside that van. If you could open up attachment 5 to your deposition, let us know when you're there.
Yes, I have it here.
Do you recognize this photograph, ma'am?
Yes, this is the inside of Lou's van. This is what the inside looked like when I saw it at the airstrip that day.
Your Honor, permission to publish this exhibit onto the screen. I believe it's been entered as Plaintiff Exhibit 4.
You may publish.
Ms. Beja, do you recognize these glasses?
I do.
Mr. Ayers, if you could zoom in on those glasses just a bit. Thank you. Ms. Beja, I want you to take a careful look at your screen. Can you tell us who those glasses belong to?
These are definitely Lou's glasses.
Thank you, Mr. Ayers. Now let's talk about what you were doing that night, ma'am. Where were you the night your husband disappeared?
Well, first I was at home, and then I went to the grocery store.
What time did you go to the grocery store?
3 a.m.
Miss Beja, why were you going to the grocery store at 3 a.m.?
Well, I was taking care of some newborn tiger kittens at the time, and as anyone who's raised children would know, that sometimes means some sleepless nights. So I had to go out and get some milk and formula.
Is there anyone who can verify where you were that night?
Yes, my brother. My car broke down, so I had to call him and he gave me a ride home.
Miss Beja, did you see your husband at all that night?
No. Earlier that night, I didn't think much of it. I was in the nursery, so even if he had come home, I wouldn't have seen him. But later on, when I came back from the grocery, Lou wasn't home.
Now, I want to ask about some of the evidence that was presented by the plaintiff today. Have you been sitting there throughout trial today, Miss Beja?
Yes, sir.
Earlier, we heard some testimony that was read from someone who calls himself Exotic Bob. Do you know this person?
Unfortunately,
Who is he?
he used to own a tiger park, and now he's in prison.
Well, they read some statements that you confessed to killing your husband to Exotic Bob. Is that true, ma'am?
Of course not.
So we also heard evidence today that your husband asked you for a divorce. Was that true?
Yes, earlier that summer, Lou did ask me for a divorce, and at one point he did try to get a restraining order against me.
At the time that Lou disappeared, what was your relationship status?
We were still married, still living together, still working together. We talked about our issues and we were trying to work through them.
Now, the plaintiff, they also spoke quite a bit about a will. Mr. Ayers, if you could put that up on screen. Your Honor, permission to publish. It's been entered into evidence as Exhibit 3.
Permission granted.
Ms. Beja, do you recognize this will?
Yes, this is Lou's will.
When is this will dated?
June 14th, 2012.
Now, to the best of your understanding, ma'am, according to this will, how did your husband choose to divide his estate?
He left it to me.
Ma'am, how do you explain that this will, which leaves everything to you, is dated 2 days after your husband's request for a temporary restraining order?
I don't know. I didn't write the will.
Okay. Well, earlier, Cam Donaldson testified that you actually broke into your husband's office and took a lockbox. Is that true?
Of course not. I'm a co-owner. Why would I need to break in?
Ms. Beja, did the police ever question you after your husband disappeared?
Yes, they questioned me and they searched my house.
When you say they searched your house, What do you mean by that?
Well, I mean, they looked for physical evidence. They even looked through our meat grinder, which we used to prepare food for the tigers.
So after the police questioned you and searched your home, were you ever arrested?
No,
After they questioned you and searched your home, were you ever charged with a crime?
no, they searched the house and that was the end of it.
To the best of your knowledge, ma'am, were you ever named as a suspect in any crime?
No.
Thank you, Ms. Beja. Your Honor, we have no further questions at this time.
Any cross-examination?
Yes, Your Honor. May I proceed?
You may.
Good evening, Ms. Beja.
Good evening.
I'm going to ask you a couple of questions about your husband's disappearance on the dates of August 17th and 18th of 2012. Now, you're aware that your husband was declared missing on August 18th, right?
Yes, I declared him missing. I asked for him to be declared missing.
And you heard testimony today that that he was last seen by Ms. Donaldson the afternoon of August 17th, right?
That's right.
So I want to talk to you about what you were doing between that Friday afternoon on August 17th to the morning of August 18th. So it's your story today that you were caring for some tiger cubs during that time, right?
Correct.
You were at home caring for these tiger cubs?
Correct.
Okay. And these tiger cubs, they weren't at the sanctuary then, were they?
No, they were at my home.
Right, your family home. And at
Yes.
some point, and you told us that at some point in the middle of the night, around 3 a.m., you went to the grocery store.
That's correct.
That was because you were buying formula for these tiger cubs, correct?
Right. They need to be fed around the clock.
Now, while you were caring for these tiger cubs, you didn't have another employee with you, did you?
No, I was alone.
And you didn't call another employee to go pick up the formula instead of you, right, Ms. Baja?
No, I went myself.
And you also didn't bring with you a receipt from that grocery store to support the fact that you actually did go to the grocery store, right, Ms. Baja? Beja, excuse me.
Well, I don't usually keep receipts for milk from 8 years ago, so I'm afraid not. I don't have that.
Well, that receipt would have been a business expense, wouldn't it have?
Yes.
And as you mentioned before, your husband was declared missing on the 18th. The police investigated soon after that, right?
That's right.
And you didn't provide any receipts at that time to the police?
I did not.
So you also mentioned earlier that on the way back from the grocery store, your car broke down, right?
Yes, it was a terrible night.
Okay, and that's why you called your brother.
That's right.
Your brother's a police officer, right?
Exactly.
And he was working at the time that you called him.
Yes.
You asked your brother, who was in the middle of his work shift, to come and help you out, right?
He was in the area, so yes, I asked him for a lift home.
And you didn't call another employee to come help you?
Well, it was 3 a.m. I didn't think anyone would be up, so no, I didn't call anyone else.
You also didn't call your husband to come help you?
Well, I knew my brother was in the area, so it just seemed sensible to call him, but no, I did not call my husband.
And you didn't bring with you any receipts of your car being towed or repaired in order to support the fact that your car actually broke down, right, Ms. Beja?
That's correct.
Now, at your sanctuary, you have a meat grinder, right?
I believe that meat grinder is at my home.
The meat grinder is at your home?
Yes.
Okay. And this meat grinder, it's for the cats, right?
Yes, it's to prepare food for them. That's correct.
Now, that meat grinder, it takes 2 people to operate, right?
Exactly.
And that night, your brother took you back home, correct?
That's true. He dropped me off and he left.
And that meat grinder is a large enough machine that you could theoretically fit a person through it, right?
That's true. And some people did theorize that that's how I killed my husband, but the police tested the machine and no remains were found.
Ms. Beja, you talked about your relationship with your husband on direct examination for quite a bit, right?
Yes,
You mentioned that he's your soulmate,
of course.
that you cared for him deeply.
Absolutely.
You're aware of his hobbies, that he liked to fly planes,
Of course.
and you know that he liked to fly planes to places like Central America, right?
Yes.
Now, Ms. Beja, after your husband was declared missing, you didn't hire a private investigator or somebody to look for Mr. Donaldson in Central America, did you?
I did not.
You didn't hire somebody, a private investigator, or anybody to scour that 2,000-mile stretch of ocean to see if maybe something happened to his plane, did you?
I did not.
Now, you heard the testimony from a man named Exotic Bob today,
I did.
and you know who Exotic Bob is, right?
Yes, I do.
Met him before?
I have.
Now, I also want to talk to you about what happened just 2 months before your husband disappeared. Now, at that time, your marriage was having some difficulties, right?
There were some difficulties, yes.
And one of those difficulties was your husband filed a request for a temporary restraining order, right?
Right.
And that was filed on June 12, 2012.
Correct.
Now, you declared Mr. Donaldson dead in 2017, right, Ms. Beja?
That's right.
And after you declared him dead, you presented a will to probate court.
I did.
And that will, it's dated June 14, 2012, just 2 days after that request for a restraining order, right?
That's right.
Now, you mentioned on direct examination when Mr. Trevisani asked you about this that you have no idea why Mr. Donaldson apparently wrote the will that he did, right?
I'm sorry, could you repeat the question?
You don't know why Mr. Donaldson supposedly left you all of his money, right?
I assume because he loved me, but
well,
yeah.
Specifically, Mr. Trevisani, he asked you about that 2-day difference from June 12th to June 14th. So you don't know what Mr. Donaldson was thinking during that time period, right?
No, I don't.
He never told you the reason why?
Well, he trusted me to take care of the sanctuary, so I believe that he wanted me to use the funds to continue his business.
Well, that will that you presented, it has 2 witnesses, correct?
Yes.
Ms. Baja, one of them's you, right?
That's right.
You're telling us today that you witnessed Mr. Donaldson sign that will.
Absolutely.
Now, during that time, while you were witnessing that signature, you didn't bother to ask him why he filed that restraining order and suddenly had a change of heart?
No.
Okay. Now, this will that you presented also contains the phrase die or disappear, right?
I believe so.
But technically speaking, this will would come into effect even if Mr. Donaldson just vanished, right?
I don't know much about the law, but I assume so, yes.
And Ms. Beja, this will leaves you all of Mr. Donaldson's property, correct?
That's right.
That's amounting to $5 million.
Correct.
You were also awarded his life insurance policy, also amounting to $5 million, correct?
Correct. So it would be a total of $10 million.
Thank you, Ms. Beja. We have no further questions.
Redirect?
Yes, Your Honor. Ms. Beja, I just want to make sure that we understand everything that you received. How much money did you receive years later after your husband's disappearance as a result?
Well, I received $5 million for the business and the same amount from the life insurance policy. But I would trade it all to have my husband back home.
Thank you, Ms. Beja. Your Honor, we have nothing further. Barring any recross, may Ms. Beja be excused?
She may. And before we begin the next witness, I forgot to ask for a time check. Do we have a timekeeper that could tell us how much time we have left for each party?
Yes, Your Honor. We're calculating it right now. I just am taking the.
That's okay.
time.
Why don't we can start this witness, and if you don't mind just calculating it so the parties know for closing how much time they have. That would be
Of
great.
course.
Thank you. All right, we can proceed if does defense have any additional witnesses that they would like to call?
Yes, Your Honor. I'm sorry. When I click on the start video, it says that the host has paused my video.
Did that fix it?
Thank you, Your Honor.
I'm sorry. I don't know why I stopped your video.
The defense.
All right. If you have any further witnesses, you may call them.
Yes, the defense calls Chris Renard. May I proceed?
You may.
Good evening.
Good evening.
Please introduce yourself to the jury.
Yes, my name is Chris Renard, and that's spelled Renard.
What do you do for a living, Ms. Renard?
I'm a death claims investigator with the Summit Life Insurance Company.
And how are you involved in today's case?
Well, I was hired to investigate the disappearance of Mr. Lou Donaldson.
Why were you investigating the disappearance of Lou Donaldson?
So Karen Baja filed a claim for life insurance, and I wanted to see if we had a basis to deny that claim.
What would you need in order to deny that claim?
Well, if I found that there was some credible evidence that she was involved in Mr. Donaldson's death.
Before we talk about the specifics of your investigation here, I want the jury to get a sense of your qualifications. Can you summarize your education background?
Yeah, so I have a Bachelor of Arts in Criminology, and then I also graduated from the Statesville Police Academy.
Where have you worked as an investigator?
Well, I started off by working in the Statesville Bureau of Investigations Crime Lab, and then I've worked with the Summit Life Insurance Company for the past 20 years.
So how many years total have you worked as an investigator?
For 23 years.
Do you have specific training in investigating death claims specifically?
I do. I receive annual training in investigating death claims.
Do you have experience reviewing documents?
I do.
Do you have experience interviewing eyewitnesses?
Yes, I do.
Do you have experience investigating possible crimes?
Yes, I do.
Your Honor, we tender Chris Renard as an expert in death claims investigations.
Any objection?
No objection, Your Honor.
At this time, the expert will be admitted in death claims and pursuant to 702.
Now, Ms. Renard, you said that you were investigating Lou Donaldson's disappearance. What possibilities did you look into?
I looked into two primary possibilities. The first one being the plaintiff's theory that Ms. Baja had something to do with her husband's disappearance. And then the second one being the possibility that Mr. Donaldson accidentally crashed his plane somewhere in the ocean between here in Statesville and Costa Rica.
Let's start off by talking about the plaintiff's theory that Ms. Baja killed her husband. Now, as part of your investigation, what sort of evidence did you look into when you were examining this possibility?
Well, I would look at eyewitnesses as well as physical evidence.
Did you interview potential eyewitnesses?
I did. I spoke with several members of Lou Donaldson's family, as well as his friends and business associates.
You said that you spoke to some members of Lou Donaldson's family. Did you have a statement from the plaintiff, Cam Donaldson?
I did.
Did you have any statements from the sheriff's department?
I did. I have a contact with the sheriff's department, so I received some information about the investigation that they conducted.
Other than interviews, what other evidence did you collect?
I collected the financial records of Mr. Donaldson, as well as police reports and photographs of Mr. Donaldson's car.
And at the end of your investigation, what eyewitness evidence had you found linking Karen Beja with her husband's disappearance?
None.
At the end of your investigation, how much physical evidence had you found linking Karen Beja with her husband's disappearance?
None.
So let's talk about the second thing that you said you investigated, the idea that Lou Donaldson could have died in a plane crash. Why did you investigate this?
Well, according to Mr. Donaldson's daughter, the plaintiff Cam, Mr. Donaldson was a pilot and he often flew his planes to Costa Rica.
Were there any particular pieces of evidence you relied on when you were looking into this possibility?
Yes, his van.
Your Honor, may we republish what's already in evidence as Plaintiff's Exhibit 5?
You may.
Have you seen that picture before, Ms. Renard?
I have. This is the picture of Mr. Donaldson's van.
Why was this van important to your investigation of Lou Donaldson's disappearance?
Well, because both of where it was found as well as what was inside.
Where was it found?
It was found at an airstrip.
And what was inside?
Mr. Donaldson's glasses.
Your Honor, may we republish what's already in evidence as Plaintiff's Exhibit 4?
You may.
Ms. Renard, why were these glasses significant to your investigation?
Well, the plaintiff stated that Mr. Donaldson would never fly without his glasses, so it was significant to me that I found them in his car.
I want to push back on this theory a little bit. Did you find any evidence of a flight plan or flight log by Mr. Donaldson on the weekend he disappeared?
I didn't, but I did find some evidence of why there might not actually be a flight plan.
What do you mean by that?
Well, Cam Donaldson said that her father's pilot's license was suspended, but she said that instead of stopping flying, Mr. Donaldson would just stop documenting his flights.
You said earlier that you also looked at financial records. In your electronic notebook, could you find the document called a bank account statement? And let me know when you've got it there.
Yes, give me just one moment here. Okay, I have found it.
Do you recognize that document?
I do. This is the bank account statement that I reviewed.
Your Honor, this bank account statement comes with a certificate of authenticity by the bank manager from Statesville Bank. We offer it into evidence as Defense Exhibit A.
Any objection?
No objection, Your Honor.
Ms. Renard, was this document significant to your investigation?
Yes, it was.
Why?
Well, Kim Donaldson said that she last saw Lou on August 17th of 2012. And after that date, as you can see on the bank records, all the activity just stops in his bank account.
Why was the lack of activity after 2012 significant to your investigation of Lou Donaldson dying in a plane crash?
Well, if he died in a plane crash that night, that would explain why his bank account activity suddenly just stopped.
Ms. Renard, at the end of your investigation, after you collected all this evidence, what did you do?
Excuse me, I had our insurance company pay out the life insurance to Miss Baja.
Thank you. I have no further questions at this time, Your Honor.
Thank you. Any cross-examination?
Yes, Your Honor. May I proceed?
You may.
Now, Ms. Renard, it's true that forensic document examination is your specialty, right?
Yes, that's true.
So that's what you've been certified in.
Yes.
You've never received any training in murder investigations, right?
Not specifically. I mean, I went to the police academy, but no.
And you've never actually worked as a police officer?
No, I haven't.
You've never worked as a detective?
No.
In fact, isn't it true that the closest you've ever come to law enforcement was as a document examiner in a crime lab for 3 years?
Yes, that's true.
Now, you didn't do your own independent investigation outside of examining Mr. Donaldson's will, right?
No, I didn't.
In fact, everything you learned was based on a far prior police investigation, right?
Yes.
Now, isn't it true that you don't know who drove Mr. Donaldson's van to that airstrip?
No, I don't. That's true.
You don't know if it was Ms. Baja?
Nope.
You don't know if it was her brother?
Nope, I don't.
And you talked about Mr. Donaldson's bank account earlier. Isn't it true that a lack of activity after August 17th would be consistent with Mr. Donaldson being murdered on August 17th?
It could be. I mean, like I said, it can also be consistent with him dying in a plane crash.
But that's a yes to my question that it could happen if he was murdered.
Yes.
So you had two aspects to your investigation on behalf of Summit Life, right?
I did.
So there was the investigation that you talked about into the police investigation, right?
Right.
And you also looked at Mr. Donaldson's will, right?
I did.
And didn't you find it suspicious that the will contained the phrase, "if I ever disappear"?
Yeah, I mean, it was something I hadn't seen before, so it was a little suspicious.
That's right. You've reviewed hundreds of documents in your time as an insurance investigator, right?
Yes, I have.
And isn't it true that you've never seen a single other will that contains that phrase?
Yep, that's true.
Now, part of your investigation was looking at Mr. Donaldson's signature, right?
Right.
And you've done training to help you see if something might be a forgery, right?
Yes, I have.
And in that part of your investigation, you actually prepared a report, didn't you?
I did.
And you would recognize that report today, right?
Yes, I would.
I'd like to have the signature comparison with a Bates number ending in 007 marked as Plaintiff's Exhibit 6. Ms. Renard, is this a signature comparison that you prepared?
Yes, it is.
Plaintiff offers Exhibit 6 in evidence.
Any objection?
No, Your Honor.
Plaintiff's Exhibit 6 shall be admitted and you can publish.
Ms. Bartos O'Neill, if you could publish this to the jury, that would be great. Now, in this investigation that resulted in you comparing these signatures, you just compared two signatures to Mr. Donaldson's will, right?
Yes, that's right.
And you actually saw differences between both those signatures?
Yes, I did.
Comparisons, yes.
Yes,
And you saw differences between those signatures and the one on the will, right?
I did.
And isn't it correct that your final determination was you can't say if this will was a forgery?
Yeah, that was my conclusion.
No further questions, Your Honor.
Redirect?
Yes, Your Honor. Can that exhibit that's on screen be taken off screen, please? Ms. Renard, opposing counsel just asked you a lot of questions about a will and comparing handwriting. Was this significant, and was the handwriting comparison that you performed significant to your investigation of Lou Donaldson's disappearance?
No, it wasn't.
No further questions. May this witness be excused?
Yes. Any further witnesses or readings by the defense?
No, Your Honor. At this time, we rest our case in chief.
Right. If the defense rests, anything further from the plaintiff prior to us taking our last break before closing arguments?
Your Honor, my only request is that if we could extend that 5-minute break to a 7-minute break, so I may squeeze in a trip to the restroom real quick.
Yeah. Why don't we just make it 10 minutes? That's completely fine. So let's, and then I do want to get just a time check for everybody so that we know time frame wise that everyone's on track.
Yeah, Your Honor, the prosecution has approximately 20 minutes remaining, and the defense has approximately 21 minutes remaining.
Perfect. Does that sound fair and adequate to both sides?
Yes, Your Honor.
It's amenable to us, Your Honor.
Okay. So let's take a break and we will be back at 9:03. All right. All right, do we have all of the parties back and ready to proceed to closing arguments?
Your Honor, before I proceed with my closing argument, I just wanted to make note that I will be referring to a few documents that came into evidence today, namely Exhibit 6, the signature comparison, and Exhibit 3, the will. However, I won't be using the share screen function. I'll be holding up an equivalent copy, if that's okay.
That's fine.
And the second thing I wanted to ask is if it would be possible for the bailiff to give me some sort of countdown so I can see where I am with my time.
Yes, that is fine. I don't know. Timekeeper. I know that your name is not Taylor Pride, but that's what I'll call you for now. Is there an easy way for you to give her a signal, or that you guys have worked out?
I can give like a 5-minute warning if that's okay.
Actually, for the record, I don't intend on using the full 20 minutes. More, I just want to see where I'm pacing myself. So if it's possible, if you could give me a marker like after 10 minutes, like if you could show me how much I have left and then theoretically count down from there.
Sure. Yeah. Like pop on the screen to show like 10 minutes.
If that's all right, and if that's not too much trouble or
Yeah.
I'm wondering if, just because I will put you on the main screen for closing arguments, there is a function at the bottom that says chat, which you all should be getting notifications. So I think it might be easiest and less distracting if you just put 10 minutes in the chat function, and then at least you'll see a little blurb pop up at the bottom and should get a noise also. And so I think that should work better than flashing or holding up hands. All right. Any requests for defense before they proceed with their opening or closing? I apologize.
No, Your Honor, we're ready to proceed.
Okay, great. Then you may proceed to closing arguments.
Yes, Your Honor. At the beginning of today's trial, my co-counsel, Ms. Parman, told you that this was a case born of greed and cloaked in deception. That's what we've proven today. When threatened with a divorce, Ms. Beja was at risk of losing everything that she had known for the past 20 years. Motivated to keep what she had, she killed Mr. Donaldson. Motivated to keep even more, Ms. Beja robbed Mr. Donaldson in his death of his plan in life by fabricating a will that left her everything. Members of the jury, today, you are the decision makers in our justice system. And this is a critical and rare task. Few countries in this world rely on their citizens to be the decision makers in their court. And this burden and duty is yours and yours alone. Today, we came in as a plaintiff with a different type of burden, the burden of proof. And we have the burden today because we're the ones that brought this claim in the first place. And jury instruction number 7 tells you what that burden is. We had to prove all the elements of wrongful death to you by a preponderance of the evidence, meaning more likely than not. What that means, members of the jury, is that you don't have to be 100% certain about what occurred today in trial. It's okay if you have some questions without answers. It's okay if you have doubts. As long as you find that the events occurred more likely than not, just a feather over 50%, then we will have met our burden. Jury instruction number 13 tells you what elements we had to prove today. To prove that Ms. Beja is legally responsible for Mr. Donaldson's death, we had to show you that 1, Mr. Donaldson is indeed dead. 2, that Ms. Beja's reckless or intentional conduct caused Mr. Donaldson's death. 3, that Mr. Donaldson's death harmed Cam Donaldson, his daughter. And 4, that Ms. Baja's conduct was the cause of that harm. Now, members of the jury, only one of these elements is truly in dispute here today. We've stipulated earlier that Mr. Donaldson is indeed dead, and I can't imagine that defense counsel is going to come up here after me and say that Cam Donaldson hasn't been harmed by the absence of her father. So what this really comes down to is whether Ms. Baja's conduct caused Mr. Donaldson's death either intentionally or recklessly. So how did Mr. Donaldson's death happen? Now, the situation would be ideal if we had something like a videotape. If we had a videotape, we wouldn't even need to do a trial. But that's not the reality of things. Now, jury instruction number 10 tells you about something called circumstantial evidence. The law recognizes that for some crimes like murder, only the perpetrator and the victim truly know what happened. And that's why you can rely on other sources of evidence. Take, for example, if you woke up one morning and you looked outside and you saw that there was snow on the ground that you hadn't seen before, you would know that it snowed overnight. You don't have to see the snow falling in front of your face for you to know that it happened. That's why you can rely on other sources of evidence, like motive, like a confession, like opportunity, like plan, in order to know something happened, even if you didn't witness it firsthand. So what evidence did we show today that proves that Ms. Baja's conduct caused Mr. Donaldson's death? Well, let's start with the confession. You heard testimony today from a man named Exotic Bob, a man who knew Karen Baja and that he had met before, and Ms. Baja admits to meeting him before as well. He told you that Ms. Baja said to him, "I will do exactly to you as I did my husband. There will be no disappearance, no mythical flight to Costa Rica. I'll feed you to my kitties just like I did him." Now, members of the jury, if you believe that confession, then we're done here. We would have met our burden of proof. But the evidence that we showed you today doesn't end there. Now, why would Ms. Baja even do something like this? Why would she be motivated to kill her husband? Well, Ms. Baja was the only person who would lose if Mr. Donaldson stayed alive, and she's the only person who would gain everything if he was dead. Now, you heard testimony today that just a couple of months before Mr. Donaldson disappeared, his daughter told you that he wanted to divorce Ms. Baja. If that happened, Ms. Baja's circumstances would change drastically. You also heard testimony today that just about 2 months before Mr. Donaldson disappeared, he put in a request for a temporary restraining order against him on June 12, 2012. Members of the jury, Ms. Baja also doesn't have an alibi for the time period that Mr. Donaldson vanished. We heard testimony from Ms. Donaldson, his daughter, today, that the last time she saw him was August 17th in the afternoon on Friday at the sanctuary. The next day, Mr. Donaldson was reported missing and was never seen again. So what was Ms. Baja doing during that time period? Well, today she told you a story of how she was caring for some tiger cubs and needed her help at her home, not the sanctuary where all her supplies were, but at her home. And at some point in the middle of the night at around 3 a.m., she ran out of formula and she had to rush to the grocery store. And on the way back from the grocery store, her car happened to break down and she had to call her brother to head back home to those tiger cubs. Members of the jury, I want you to think carefully about that story she told you today. Where is the business receipt to corroborate that she actually went to the grocery store that night? Where is the receipts to corroborate the fact that her car had actually broken down, either to show that it had been towed or that it had been repaired? Why wasn't an employee with her at any point during the night, either to help take care of the tiger cubs, either to go and make that errand to the grocery store, or to pick her up and take her back to the tiger cubs when her car broke down? You'd think that in a circumstance when you're doing work for your sanctuary, that you would ask somebody else who worked with you to help. Instead, she called her brother, who's a police officer, in the middle of his shift to come pick her up. She didn't call an employee. She didn't call her husband either. She called her brother. And they headed back to their home, where she told you that's where they keep their meat grinder. A meat grinder that needs to be operated by 2 people. A meat grinder that is large enough to fit an entire human body. We also have evidence that Ms. Beja tried to cover everything up. And this started just the day after, on August 19th, a Sunday. You heard testimony today from Ms. Donaldson that on Sunday, August 19th, 2012, she was alerted to an alarm at her father's home. She rushed over and she saw Ms. Baja there with a lock cutter in her hands and saw the broken gate and the broken lock on the locks box, a place where Mr. Donaldson had kept his will. Instead, the will that was presented after Mr. Donaldson was declared dead in 2017 wasn't one that Ms. Donaldson recognized. It was a completely different one. Ms. Baja presented this one, labeled Exhibit 3. This will she presented was dated for June 14th, 2012. Just 2 days after that request for a temporary restraining order was filed by Mr. Donaldson. And that's something Ms. Beja knew about. She knew about that request for a temporary restraining order, and allegedly she knew about the creation of this will too. She even told you and testified on the stand today that she witnessed Mr. Donaldson sign this. You'd think that she would ask, why have you had a change of heart? Why did you make that change from filing that request to suddenly leaving me every single bit of your property amounting to $5 million? Members of the jury, it just doesn't make sense. I want you to think about the credibility of Ms. Beja's testimony. Jury instruction number 12 tells you that you get to decide the credibility of the witness and their testimony, and you get to decide the weight that you give it. Ms. Beja's story just doesn't make sense. And there are many other reasons why this will is fraudulent. For one, Ms. Baja is labeled as a witness to this will, even though she stands to gain from it. It also includes a phrase to die or disappear, a phrase that both experts, Ms. Taylor Pride and Chris Renard, acknowledge is an uncommon phrase for a will to have. Furthermore, you heard testimony today that the signature on this will is forged. Now, Taylor Pride, a private investigator with 16 years of experience as a detective and even more experience in economic crimes, document examination, forgeries and fraud and handwriting analysis, told you that the signature on this will contains all the hallmarks of a forged signature. And members of the jury, you don't have to take Ms. Pride's word for it. You can make the assessment yourself. When you go back in your room to deliberate the results of this trial, you're going to have Exhibit 6. This document contains Mr. Donaldson's verified signatures, one from his driver's license and another one from an insurance paperwork that he had filled out and signed. You can compare those 2 verified signatures to the one on the will, and you'll see that the one on the will Ms. Beja presented is the odd one out. Now, the defense has tried to distract you, to deflect your attention in a cover-up of telling you that Mr. Donaldson probably took a plane out to Central America and crashed on the way there. But the idea of that, when it comes down to it, is just absurd. Now you learned today that Mr. Donaldson's glasses and his keys were found left behind. Rather than showing that they may have been forgotten, what that perhaps truly indicates is that maybe he didn't leave at all. You also heard testimony from Ms. Donaldson, his daughter, that he would always tell her where he was going. He didn't mention any trip to Central America or Costa Rica. And despite Ms. Beja's suspicions, despite the fact that she knew about his hobbies to fly and go somewhere else, after he was declared missing, she didn't hire a private investigator to look for him in Central America or to scour the thousands of miles of oceans right after he disappeared. This story about a plane trip to Central America just doesn't make sense. We have met our burden of proof to show that Ms. Beja's conduct caused Mr. Donaldson's death. And because of that, if you find that the evidence shows more likely than not that that happened, when you get this jury verdict form right here, you should answer yes. And the last thing that you'd have to fill out is how much to award Ms. Donaldson in terms of damages. Now, members of the jury, you'll notice that we didn't call an expert to tell you or how you should make that assessment of what amount to give. And that's because you're the expert on how much you should award. And I know it can be uncomfortable to assign a value to someone's life, to someone's suffering. But members of the jury, what you must remember is that you cannot make that value, that time that Ms. Donaldson spent with her father and then no longer can replicate, valueless. Now, jury instruction number 4 gives you some more guidance on how you might award those damages. For economic damages, we are asking for $10 million. And the reason why is because Ms. Beja deprived Ms. Donaldson of that amount when she created that fraudulent will. Now, you're not just limited to economic damages. You can also assign an amount for non-economic damages, such as suffering, grief, and emotional distress. And for that amount, we're asking for $30 million. You heard testimony today that Ms. Donaldson wanted to redo that last moment she saw her father. And she has to live with the fact that every moment, every life event afterwards, she has to do without him. And all because of Ms. Beja's greed. For the past 8 years, Ms. Donaldson has had no closure. She can't lay her father's body to rest. She can't continue his dream of saving big cats. And that's because this case was born of Ms. Beja's greed and cloaked in her deception. You don't need a videotape to tell you that. We ask that you find Ms. Beja liable and award Ms. Donaldson $40 million. Thank you.
Thank you, counsel. Closing argument for defense.
Your Honor, just a clarifying point. Do we want warning? Does the defense want warnings as well? Sorry.
No,
That's
thank you.
fine.
Okay.
Your Honor, before I proceed, permission to publish any exhibits on screen that have been entered into evidence?
Permission granted.
Thank you. May I proceed?
You may.
2,966. That's how many days it's been since Lou Donaldson disappeared. And in 2,966 days, no one has found his body. Not the plaintiff, not the police, not the private eyes. Why? Because they were looking for a murder victim. Even after they found Lou Donaldson's van at an airstrip, no one considered the obvious. That when an aging man flies alone at night without his glasses, his plane might go down. You see, when someone is murdered, it's hard to hide a body. But when a plane goes down in the middle of the ocean, it's hard to find a body. Members of the jury, this was not a crime. This was a crash. Today, the plaintiff had the burden of proof. They had to show you that each and every element of their case was more likely than not true. Today, they failed to meet that burden because of two simple facts. Let's take them one at a time. Fact number one, it wasn't a crime. Now, opposing counsel said that today's case, it was born of greed and cloaked in deception. We agree. But it wasn't Miss Beja who showed that greed in court today. Miss Beja took that stand. She answered every question that I had for her. She answered every question that opposing counsel had. But when the plaintiff took that stand, well, she answered opposing counsel with no problem. But when I got up there to cross-examine her, you saw how combative she was, members of the jury. I mean, I wrote it down here. I asked her, you don't know how many planes your father had. Her answer, I always knew where my father was going. I asked her, you don't know if one of your father's plane is in the Gulf of Mexico right now. Her answer, she started talking about an airstrip, how she knew he only flew out of one. I asked her, why weren't the police on her witness list? And she started talking about the date that her father went missing. Members of the jury, these aren't the words of someone who is seeking the truth. These are the words of someone who is seeking money to the tune of $40 million. There's no evidence of a homicide here. Sure, they told you a story today about a death threat. But consider the source. Who did that come from? The only person who testified about a death threat was the plaintiff, who wants $40 million. We heard a similar story about a shouting match between Lou Donaldson and Miss Beja. The only person we heard that story from was the plaintiff, who wants $10 million. We heard another story from the plaintiff about a break-in that Miss Beja broke into Lou Donaldson's office and stole his financial documents. Members of the jury, there were 4 people that were supposedly there that night. Only one of them took that stand today, and it was the plaintiff, who wants $40 million. So they showed you this photo of the gate and the lock. Notice who's not on your screen right now, members of the jury. Who's not in this photo? Miss Beja. And if you think about it, the story about this break-in, it just doesn't add up. Why would Miss Beja need to break in when she was the co-owner of the company? Thank you, Mr. Ayers. They talked today, actually built their case around the testimony of someone named Exotic Bob. Members of the jury, the reason he wasn't in court today is because he's in a prison cell. They had nothing to corroborate the rumors, the shred of evidence that came from Exotic Bob. And that just shows you that the plaintiff, they didn't have a leg to stand on today. So they called Taylor Pride to talk to you at length about handwriting. Members of the jury, this is not a forgery case. They showed you this will. They talked about the signatures. They want you to pore over them. But this, it's a wrongful death case. What did they do to prove wrongful death? Well, they talked a lot about Miss Beja's behavior on August 19th. They said she was suspicious, that she was going out late. It doesn't add up. Members of the jury, don't you think that if Miss Beja was going to invent a story about her whereabouts that night, she couldn't have come up with something a little bit better? I mean, the plaintiff wants to have it both ways. On the one hand, Miss Beja is a master criminal. She can make a body vanish without a shred of evidence. On the other hand, she wasn't smart enough to come up with a better alibi. So far, I've talked a lot about the evidence that the plaintiff did present. But let's remember the evidence that the plaintiff didn't present. Miss Beja was investigated thoroughly, not once, not twice, 3 times. First, the police, they came to her home. They searched every square inch. They searched that meat grinder. They found nothing. The insurance company, they paid Chris Renard to look for any reason to deny Miss Beja's insurance claim. And then the plaintiff, well, she hired a third investigator to come in and look into Miss Beja. And what did all of these investigations have in common? They found zero, zip, zilch, nothing. There are no eyewitnesses of a crime. No one took that stand and told you that Karen Beja killed her husband. No one saw her burying her husband. No one even saw Karen Beja and Lou Donaldson together at all that weekend. There's no physical evidence of a crime. There's no blood, no DNA, no fingerprints. Their own witness, a former police detective, took that stand and told you under oath that we don't have the most basic elements of a crime here. There's no murder weapon because there wasn't a murder. No signs of a struggle because there was no struggle. No crime scene because there wasn't a crime. Normally, when you accuse someone of killing another human being, you have evidence. At the very least, you have a theory. A theory is, it's Colonel Mustard in the library with a revolver. Their theory is Karen Beja in the somewhere with the something. The plaintiff has failed to meet their burden. So you might be asking yourself, if she didn't kill him, then what happened? If this wasn't a crime, then what was it? That brings us to point number 2. This was a crash. Lou Donaldson loved to fly. He flew all the time, especially to Central America. And where did the police find his van but an airstrip? This is actually the biggest clue that we have as to what happened the night that Lou disappeared. The plaintiff testified that when he left the office that day, he drove this van and she never saw him. This van was then located at an airstrip just 40 miles away from that office, and Lou Donaldson was never seen alive again. Now, the plaintiff, they did their best to wave away this explanation of events. They talked about glasses. They said, well, he couldn't see without his glasses. He wouldn't have been able to fly without his glasses. Members of the jury, that's our point. Lou Donaldson, he couldn't fly safely without those glasses. And the plaintiff said, well, Lou Donaldson would always tell me where he was going. He would always tell me about these trips, but we know that's not true, members of the jury. We know that Lou Donaldson would often only tell folks about his trips afterwards. They might say, there's no evidence that a plane is missing, but we heard again and again that no one knew exactly how many planes Lou Donaldson had. We don't know if one of those planes went missing. Miss Pride, she talked to you about how she sent investigators over to Costa Rica, that they didn't find anything, no evidence that Lou stepped foot in Costa Rica. Members of the jury, we agree. Lou took off that night. He just never landed. Now, they might tell you there's no evidence of a plane crash. But the truth is, no one looked for evidence of a plane crash. The police investigated here in Statesville. The plaintiff sent folks over to Costa Rica, but no one searched the 2,200 miles in between. And Miss Pride said it the best under oath on the stand today. The focus of the investigation was not where Lou Donaldson was. And the fact is, there is evidence of a plane crash. A plane crash explains why there's no blood. A plane crash explains why there are no eyewitnesses. A plane crash explains why 8 years later, no one has found a body. Members of the jury, all of the evidence that's missing from their theory, it's explained by ours. Now, in a moment, the plaintiff is going to come back up here. I expect that they'll mock the idea of a plane crash. That's why you have to ask yourself, what is more likely? That a woman who cares for cats was able to pull off the murder of the century without leaving a speck of physical evidence, evading 3 different investigations, or that an aging pilot flying at night, flying alone, flying 2,200 miles, flying without his license, flying without his glasses, didn't come home. I submit to you that our version of events is far more likely. But we didn't have the burden, members of the jury. The plaintiff had the burden. Not a burden of rumors, not a burden of speculation, a burden of proof. They failed to bring you that proof today. That's why we're asking you to return a verdict in favor of Miss Beja. Because this was not a crime. This was a crash. Thank you for your time.
Thank you very much. Does the plaintiff have a rebuttal that they would like to present?
Yes, Your Honor.
And I believe based on the prior chats that you have approximately 5 minutes. Is that correct, AKA Taylor?
I have 4 minutes left.
4 minutes. Okay, wonderful.
This was a case born of greed and cloaked in deception. And let's talk about what this case isn't. This isn't a game of Clue. This isn't a criminal case either. What you have before you, what you are assessing, members of the jury, is a wrongful death case where the burden of proof is by a preponderance of the evidence. Mr. Donaldson disappeared over 8 years ago. And so it makes sense that we're not going to find the evidence that the police or anybody else would have found just days after that occurred. And so I want you to focus on what we do have here today, 8 years later. Now, when the defense makes a claim that Mr. Donaldson took off and crashed, I'm not going to come here and try to mock that claim. But what I want to tell you, members of the jury, is that when the defense makes a claim such as that, you get to make an assessment on the credibility of that claim. I want you to think about the evidence that we've seen today to support the fact that Mr. Donaldson may have crashed. We know that Mr. Donaldson not only left his glasses behind, but he left his keys behind too. We also know that he would tell his daughter where he was going. There was no evidence to show that Mr. Donaldson was planning on taking a trip. The idea of him crashing is just absurd. There's no evidence to support that in your assessment, members of the jury. You can assess the credibility of that claim. So let's focus on what we do have. What we have is a forged signature, a fraudulent will, and a timely threat of divorce that was delivered to Ms. Baja. And even Mr. Trevisani thinks that Ms. Baja could have come up with a better alibi. What we heard today is that Ms. Baja has no credible alibi for the night that Mr. Donaldson disappeared. What we know is that she and her brother had access to a meat grinder that night, and that there was a confession from Ms. Baja to Exotic Bob on what happened to her husband. You learned today that Ms. Baja had everything to gain from Mr. Donaldson's death, and the amount of $10 million. This case was born of greed and cloaked in deception. We ask that you find Ms. Baja liable. Thank you.
Thank you very much. If everybody could please unmute their mics. I think I have a way to do it. All right. And I would, let's see here. I just want to give you guys all a round of applause. You did a great, fantastic job. First virtual trial that I have participated in. So I just wanted everyone to give you guys a round of applause and tell you how fantastic I thought each and every one of you did. I know that it's not the same impact as being in trial and getting to present, but I thought each of you did just a marvelous job. So congratulations to everyone. You guys did great.
Thank you.
And I don't know, we have Bobby and Tracy who are our co-judges. If you guys want, I know you're probably exhausted. Take maybe a 5 minutes total of each, judge just kind of introducing themselves and giving any just very brief feedback. If that would be helpful to you guys, we could do that. If you're exhausted, I'm also fine saying we can send you guys on your way. So it's up to you.
Yeah, no problem.
Okay.
I'm still here. My video is off though. I tried to turn my video on.
Let's see.
But
Maybe
it says that it's
there we go.
turned off. But we can do it
Host.
without the video. We can just do an audio thing.
Oh, there you are.
But I agree. I thought you all did amazing. This is the third competition that I've been a juror in or that I've judged. And both teams were incredibly prepared compared to a lot of the teams that I've seen. So I was really blown away. So I'm an assistant state's attorney for Lake County in Illinois, which is the northern suburbs of Chicago. So I live here in Chicago. I've been an assistant state's attorney for about 3 years. I'm in the misdemeanor and traffic division, which is our biggest division. I handle about 2,000 cases. Well, our division handles about 2,000 cases. I handle a few hundred every single year. I've done 18 jury trials, probably around 60 bench trials in 3 years, and countless contested hearings. So I spend, well, when there's not a pandemic going on, I spend 5 days a week in the courtroom, So I've gotten a chance to do a ton of litigation since I graduated from law school in 2015. But just briefly, I thought the openings were great. I'm sure the names of the people are wrong. And I'm just gonna kind of just go over quickly because I know it's late for everybody. So I'll just say, Ayers, I thought that your opening was great. I thought you had great tone. I thought you had great pacing, great range of emotions. I really liked the image that you conjured up of the guy on the plane going down. I thought that was really important for the jury to have that in their mind from the very beginning. And for the whoever on the plaintiff side did the opening, Hannah, I thought you did an excellent job too. I mean, I understood the entire case in the first few minutes, and as a juror, that's always what you want, to not be confused the entire trial. And yeah, I mean, you guys did great on directs and cross. I've got a lot of notes here. I'll try to give some more feedback in the comments, but I won't bore you all with those right now. I thought the closings were incredible. And Rico, I thought your closing was one of the best closings that I've heard in a real courtroom or in mock court. So I thought that you just nailed it. And I thought that you handled objections and responding to objections really, really well. I think you just got straight to the point, and you've got a good professionalism that I see with attorneys who have been practicing for a really long time. So it seems like you've got it. So keep it up. And Bartos Anil, your closing was incredible too. I just couldn't decide which way I was going to go after hearing both of you argue. So good job to both sides.
Thanks, Bobby. And Tracy, do you want to chat with all the members and introduce yourself as well?
Sure, I'll just keep it brief. I am in Seattle, Washington. My son is a DU student and he needed to volunteer. So here I am. This is my first experience with mock trial. So it was interesting for me to watch. I'm 50 years old. So I've been a juror 4 times in my life, everything from municipal court to superior. So I know what's going on a little bit. I thought you guys all did an awesome job. Witnesses, you were great. I was impressed with pretty much everyone. I took a lot of notes as well, and good job. It was very interesting.
Thank you, Tracy. And before I go, do you guys have team names or numbers for the online scoring ballots? I did not get that from you from the beginning. I just want to make sure before people start jumping off.
I believe we are Castle Peak. Alex, is that correct?
And we're Team Maroon Peak, Your Honor.
Perfect. My name is Jordan. You no longer have to call me Your Honor. You all did a fantastic job. A brief introduction. I was a DA, district attorney, for 4 years and then transitioned into private plaintiffs work. And I primarily do plaintiffs' medical malpractice. And so more of the civil side, a little different, but kind of started my career in the courtroom. I also did a lot of mock trial throughout law school. And so I know how much preparation and dedication goes into preparing these types of things. And especially when you're in the midst of a pandemic and you can't see each other and you can't confer. I just was really impressed just generally with your professionalism and how prepared each and every one of you were. I, like Bobby, will include most of my notes in the comments. As you can see, I took tons of notes throughout your guys' trial, but just a couple highlights that I wanted to point out was, Jack, your cross-examination was fantastic. I thought you brought a certain element to the room where I was like, oh, okay. Like you made me instantly pay attention. And I thought you did a great job starting in a funnel. So you started asking kind of broad, easy questions and then narrowed it down to specific things. And all of your questions were one answer, one thing you were asking for. And I just thought that that was a really big highlight of the trial for me, just your whole demeanor and the types of questions that you were asking. So I thought that was really great.
Thank you so much.
You're welcome. And let's see here, Hannah, I agree completely with Bobby, your opening statement. Motions in limine are kind of hard to rule on when I don't have an entire idea of what the case is about or what specific pieces of evidence you guys are trying to admit or exclude. But I really felt like your opening statement walked through in such a cohesive way that I had a great grasp on what the case was going to be. And I felt like you guys kind of intertwined that into your closing argument. So it was very cohesive that way. Enrico, I couldn't agree with Bobby more. That was a fantastic, fantastic closing argument. You spun the evidence the way that it should have been spun. You were making arguments, which I think a lot of lawyers fail to do. They simply stand in front of you and recite the facts, or they'll kind of get close to the argument, but they won't actually say it. And I thought you did just a great job of getting after the evidence, being a little snarky, which I like, and, kind of just being yourself. And I think that's what each and every one of you did today. But really in that closing argument, I got to see a little piece of you, which I thought was fantastic. And then is it Alex or Alexandra?
Either works.
Okay. I thought your direct examination was very well done. You have a very calm demeanor about you. And so I thought that played really well in making the witness the star throughout your direct examination. Very credible throughout your presentation. And then your objections and knowledge on the law and the rules of evidence was very apparent. And so there was a couple of times where you were making me think, what rule is she citing? Okay, I have to go back, I have to think about that. So I thought that you did a fantastic job with objections, responding to objections, and just kind of laying the case out and doing your direct examinations and cross-examination. So I thought you all did a great job, and I know that you guys will all be successful moving forward. So congratulations and good luck.
Thank you so much, all of you.
You're welcome. I think we just end it now. So
And thanks to opposing
virtual
counsel for
goodbye.
A great round, and thank you
Thanks,
to the
guys.
host witnesses as well. Thank you.
Yes. Thank you to the witnesses as well. All right, everyone have a great night.
Thanks.
All right, you too. Good night.